Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And I hate to ask, but how are y'all doing tonight? I'm doing terrible. I am doing absolutely terrible. But, you know, that's the way it goes. That's the way it goes. So just to get this right out in the start, this is a sad show for me. This is the show. The Vic Mignogna decision finally came back. And after a long time of waiting, we've got very depressing news. Very, very depressing news. Now, we're going to go through the, I don't know if we're going to read all of it. This is a decent chunk of pages, like 70 pages. A lot of that is quotes that are probably not necessary, though. There's some big block quotes and stuff like that. But we are going to go through the most important parts of the appeal decision and talk about what went wrong with the case in general and why the appeal was upheld in favor of the people who defamed Vic Mignogna. And let's be very clear about something. They did absolutely defame Vic Mignogna. And this case still has not been heard on its merits. And, well, now, of course, never will be. It will never be heard on the merits of the case. And part of that is it's due to a couple factors that are cited specifically by the court. One of them is sort of I don't know how to word this. I wouldn't call it strategy, but some of the, I guess, infield decisions made by Vic's counsel, and some of it go right back to the words of Vic Mignogna himself. These things are cited directly by the court in the documents. We, of course, will talk about that. We will face what the court has to say, and that's the way it goes. You do not, unfortunately, always get to win. And I know no one wants to hear this. And I will say it again, because I said it a long time ago, and I said it all throughout this wait. People need to expect. They need to temper their expectations and deal with the reality that most appeals do not result in overturning the decision. And that was the most likely outcome. And I fucking hate it, but it's true. It was always true. I got my hopes up at times because of how long it was taking, because of some of the other decisions that had come out in regards to TCPAs in Texas. But unfortunately, the statistics held up. The reality of the situation held up to what I initially said. And the victory is not there for Vic Mignogna. It really is. It's really, really frustrating. And I will also note that probably the largest reason, well, I shouldn't say it this way. Let me say, I'll say what I was going to say so you know, but then I'm going to rephrase it and make it a little more clear. I was going to say probably the biggest reason Vic didn't get his case overturned on appeal has to do with the rejection of the second amended petition. But that might not be accurate. So let me rephrase that with a little more clarity. The big part of the reason that Vic's appeal analysis by the Second Court of Appeals ended where it ended was because they were not able to get the second amended petition into the record as evidence. I'm not a huge fan of how the court came to their conclusions on the second amended petition, but They seem to be legally sound-ish. And at the end of the day, there's not really much you can do about it. Would the admission of the second amended petition have made Vic win his appeal? I don't know, but it would have gotten further than it did. We never know what would have happened, right? But there's a big chunk of evidence in that second amended petition that is not considered by the court. And all of the affidavits are not considered by the court, which amounts to a complete deficiency of evidence, according to the appeals court. So, with that, I'm going to do sort of a recap introduction of this case, not a long one. I will talk about my involvement with the case because there will probably be some questions about it. And I will kind of just give a brief refresher, because a lot of people who are here watching have no idea what this case was, but it was a huge part of this channel back when it happened. And there have been so many frustrating aspects of this case from a whole bunch of different sides. And they all culminate in where we are now. So if you're feeling lost right now at this little intro monologue, fear not. I will guide you to the story itself, and we can go from there. Now, stop telling me top fucking banner. Stop it. Stop. I'm good right now. All right. So with that said, let us begin somewhere towards the beginning. This is a case of Me Too run amok at the absolute pinnacle of the Believe Women Me Too moment. I won't call it a movement. I'll call it a moment. That moment would be shattered pretty quickly by things like COVID, the war in Ukraine, some rising gas prices, things like that, kind of really quickly overshadowed the Me Too movement when a bunch of people went, oh, wait, I actually don't fucking care about these people bitching about these allegations or whatever. And it's lost a lot of its sting. But this case stems from a different time. This case stems from a time when the Believe Women mantra and the Me Too movement were at their zenith, nadir. Which one is it? I don't know. The top one, the apex, the height of power. And this is a case of Victor Mignogna. He is an American voice actor for Japanese cartoons, popularly known as anime. If you have watched much anime, you have likely encountered a Vic Mignogna voice somewhere. His larger known roles are the voices of Broly from Dragon Ball. I shouldn't say Dragon Ball Z, from the Dragon Ball Super movie, and from the Dragon Ball movie universe that included 3 movies starring Broly as the title character. He was never actually in Dragon Ball Z itself, the show, because Broly was a non-canonical character until Dragon Ball Super. But he was the voice of Broly in Dragon Ball Super, the blockbuster anime release that hit in January of 2019, which is right when all of this started. Other voice roles you may notice or may know Victor Mignogna from are Full Metal Alchemist. Full Metal Alchemist is a show about 2 brothers who practice alchemy and learn the harsh lessons of life, that there's a trade-off for everything. And Vic plays Edward Ulrich, the lead character in that show. So if you've seen Full Metal Alchemist or Full Metal Alchemist Brotherhood, he is the voice of Edward in both of those English versions. Finally, the other large role that people tend to know him from in the United States is the voice of Tamaki from Ouran High School Host Club. I've never watched Ouran High School Host Club. The best I can figure is it's a bunch of gay students doing gay shit in a gay school in Japan. But I don't understand what the fuck is happening on the screen in Ouran High School Host Club. What I do understand is a bunch of people like it, and it's an anime that doesn't have robots, ninjas, or ninja-shaped robots in it, so I don't watch that shit. But a lot of people liked it. Other notable roles were Crow from the show Ruby, I think. And then was he in JoJo's? I don't know. He's got a lot of other roles all over the place because the anime world is an insular and incestuous pit of nepotism and in-group, out-group thinking. Vic was on the in-group for quite some time until he was no longer on the in-group and became on the out-group. He was Rohan in JoJo. Okay. That means literally nothing to me still. All right. So you can type him into IMDb. You'll see him in numerous films. If you want to talk to the man himself, or well, not really talk to him, but if you want to see an interview with the man himself, in which I talked to him for quite a long time, it's one of the pinned interviews on my channel, the interview with Vic Mignogna. And you can hear his story in that interview about this whole fiasco. But the summary version is this. Right on the cusp of the release of Dragon Ball Super, when press is at its maximum for the film, a tweet was made about Vic Mignogna tagging Funimation, asking why they let, creeps or pedophiles or something on the work at their studio. The interesting nature of this tweet is that the person who made it is actually retarded. I think due to a brain injury. Or maybe they got the information from someone who is retarded due to a brain injury. I can't remember. But they were actually talking about a different voice actor in their tweet. This was discovered later, deep in web forums in which this person was discussing the tweet itself. The tweet was about a man named Ilich Guardiola. Ilich Guardiola is another American voice actor of Japanese cartoons who decided to have sex with a 16-year-old. Once it was uncovered that he was having sex with an underage person, he asked permission to the person's parents and they promptly got married. Thus, charges were dropped, but Ilich Guardiola has not been super famous in the anime industry ever since then. Ilich Guardiola at one point dated Monica Rial, who ends up being a part of this case. Again, the world of anime is insular and incestuous. Following the tweet, there was a firestorm. This firestorm was fueled by certain retweets from certain people. The most important of those people, for the purposes of this case, being Jamie Marchi and Monica Rial. Jamie Marchi and Monica Rial piled on to the tweet storm that was going on over the next couple days, sharing their quote-unquote stories about Vic Mignogna. And I put a heavy emphasis on story because these stories, each time they are told, have changed quite a bit. They've also, on key facts, I should say, they've changed on key facts, and they sound very similar to other stories that have been told by other people. And if you watched through the Johnny Depp case with me, you'll note that I made a point about this, that in these Me Too accusation cases, what happens is there's an initial story, And that story doesn't seem to get the necessary traction. So it is morphed and changed and borrowed and grown. And what you find is this pile on effect of people. And I'm not quite sure the reason it happens. Uh, Believers would suggest it's because the one person who's being accused is so bad that they did the exact same thing to so many women that all the stories sound the same. More cynical people would suggest that those stories get popularized, and when they become effective and allow people to get some sort of attention or recognition for their quote unquote victimhood, they utilize the same story that other people have utilized and will repeat it or repeat something extremely similar. I think the truth on this case is more along that later line, that events that happened were distorted by other stories, and in the more salacious aspects of those other stories were incorporated into the initial stories of the events to make them worse than what they were for the purposes of defaming someone. That's my opinion. Other people might have different opinions. So this is all going on in late January of 2018. Was it 2018? Shit, I don't even remember. I guess I could look. Let me see if I have quickly I should have some quick access to an idea of the dates. Here we go, just a second. What? Oh, there we go. Sorry, I was in the wrong folder. Oh, it looks like beginning of 2019. Beginning of 2019. Sorry, with COVID, I no longer know the dates that happened. It's just BC and AC, right? Before COVID and after COVID. And 2020 doesn't exist at all. So this is at the beginning of 2019. By February of 2019, February 11th to be specific, after many calls for it from the Twitter masses. And by many calls, I mean not actually that many calls, because that's how Twitter works. It only takes a relatively small number of people to bitch about something for something to happen. But importantly, with reinforcement from people like Monica Rial and Jamie Markey, Vic would be fired as a voice actor by Funimation, the largest voice acting studio for anime cartoons in the United States. And that is when all of this really, really kicked off. And this is, most importantly, to any story, is where I come into it. Okay? This is where I come in. So by February 11th of 2019, Vic Mignogna is fired from Funimation. And quickly, this becomes a subject of discussion online. I am not a huge anime fan. I like anime, but again, I have a problem calling myself a fan of things when I'm not properly within the fandom. Again, ninjas, robots, ninja-shaped robots, sufficient amounts of murder are kind of necessary for me to watch a Japanese cartoon. I don't like slice of life anime. I don't like cutesy anime. I don't like comedy anime. Just not my thing. You can like it all you want, you degenerates, but it's not my thing. So I don't call myself like a fan, because I think that's a little more than an observer or an occasional consumer. However, I'm very interested, always am, in these accusation cases, whether they're true, whether they're false, whether someone is making up a story, whether there's any merit to it. So I start asking around and in circles that I run with people who have more knowledge than me about this scenario, what's going on, and decide to do a couple shows talking about it. The first show I did was an interview with Doug TenNapel, and this is not the main focus of the show, but since Doug TenNapel had been in the American cartoon industry for so long, I had asked him some questions about this sort of person to see if he had known anything about him. Not really much came back from Doug, but he was initially skeptical of Vic, not based on anything he knows about Vic, but based on what he knows about American American cartoon voice actors and how slimy that industry could be. But the next show was a full dedicated show, a panel discussion with Yellow Flash, Anime Outsiders, I think that Umbrella guy, and maybe Hero Hey, something like that. I can't remember the initial panel off the top of my head, but we had a panel discussion talking about the allegations. I had looked at it and asked around. I did not find much credibility in the accusations at all. But we talked about the show, or we talked about it on the show. I believe that was the show that prior to that, I had sent an email to Vic Mignogna, who I have never met prior to this point. I've never spoken to, didn't even know who he was, but I was given his email address, which turned out to be public anyway, by Anime Outsiders. And I made contact with him and just said, hey, we're doing a show talking about your situation. As a courtesy, I would like to invite you on. He politely declined to do the show, which was obviously a smart move. He should not have done the show, but, courtesy and grifting demanded that I ask, if he would like to. After the show, I was contacted again by Vic Mignogna, and a discussion of hiring a lawyer came up. I am a lawyer in Minnesota who is not licensed to practice law in Texas. I also am a solo practitioner with no greater network of resources around. I'm just a guy. I was also doing YouTube and had switched at that point to primarily doing YouTube. That was the time when I was building my channel. So I was not particularly equipped to deal with any sort of lawsuit and was not looking to represent anyone in a lawsuit, certainly not anyone in Texas. Nor would I have thought that it would be ethically sound for me to represent someone when in a case like that, where the resources were so demanding, so to speak. But that being said, I was not soliciting for any legal work for anybody, much less Vic Mignogna. However, damn, I can see the internet getting really bad. Is the bit rate really bad, or is it still going okay? We'll see. I'm blurry. Yeah, I figure it's fuzzy. Yeah, I can tell the upload link between, I'm not sure if it's between me and StreamYard or StreamYard and YouTube is unstable, but it appears to be unstable. So that's nice. Well, if the audio is fine, we'll keep going. So I was asked whether or not I knew of any lawyers who could handle that case. So I mentioned that there is a lawyer in Texas with a firm with the resources to handle a case of that size. And I made the referral, so to speak, to get into contact with a guy named Ty Beard. Ty Beard is an attorney who has done all sorts of work for my family. And that's a true fact, always has been a true fact. But I had not personally met or interacted with Ty Beard, I think, at all prior to that. I'd spoken with him on the phone, but I don't know that I had ever met Ty in person at that point. Not a close relationship for me, but a relationship did exist. A lawyer in Texas who I knew was not afraid to fight and who also had a law firm equipped to handle all sorts of things that were pretty big and dealt with high value clients all the time. So I made a referral and said, you can talk to this person and do whatever you do. It's not up to me. I didn't tell anybody to hire anybody. I don't tell anybody what they should do. But if you ask me for a lawyer referral, I try and give one. So with that, Vic contacted Ty and they decided to work together at that point. A whole lot has been said about my involvement in this case, my demand that Vic hire Ty, my demand that Vic sue these people. None of that has ever been true. I laugh it off all the time. I believe I've stated online several times that none of it's true, but none of that is true. If you ask me for a phone number, I can give you a phone number, but I can't make you hire someone. I can't suggest you hire someone. I don't really care if you hire someone. That's not really up to me. But lots of people think that I somehow forced Vic to hire Ty and demanded that Vic sue these people. Again, not true. I don't know what else to say about that. But I did make the referral to Beard and Harris. Vic followed up with it and must have liked what he heard. With that, a lawsuit was launched. The lawsuit was for defamation. There were 4 targets: Monica Rial, Jamie Markey. These are 2 fat women who voice act skinny characters in anime. A guy named Ron Toye, who is the forever fiance of Monica Rial. She knows never to marry him because he is a wife beater, according to the Texas courts and his own admissions. But that being said, the 4th party that was sued in this case was Funimation itself for their tweets made around February 11th. These 4 people were all in 4 people / entities were all in Texas, and this could all be done in Texas state court. Whether that was the right or wrong decision remains for the history books. Some people will say it's wrong. Some people will say it's right. There are questions about suing other people involved as to their ability to actually pay, as well as the logistics of conducting multi-state lawsuits. Again, not my decision. Don't really care what people decided to do. These were the 4 targets that were picked, and why they were picked will be a conversation between Vic and Ty and probably no one else. That being said, that's who was sued. The defendants in the case filed respective TCPA motions. That's the Texas Citizens Participation Act. And that is, it's an anti-SLAPP motion. What that means is it's a motion to dismiss, stating that the lawsuit itself is frivolous and designed entirely to silence the speech that should be protected by the First Amendment. Now, this is kind of a weird thing that courts are allowed to do, because technically a private party cannot silence the speech of another private party, or there's not a way for the government to stop a private party from silencing the speech of another private party. Okay. So typically there's not much you can do about it if someone is preventing you from speaking. That's what I'm trying to say. However, anti-SLAPP provisions suggest that a person utilizing the courts is not a private person doing this anymore. Instead, they're asking the government to silence or punish the speech of another person. Therefore, First Amendment concerns come in, and they crafted this anti-SLAPP statute that is in place in several states to try and combat frivolous lawsuits. Think of it this way. Let's say you go to a McDonald's and you say, these chicken nuggets are trash. They're made with white meat and I prefer dark meat, or whatever. And McDonald's says, you motherfucker, I don't like what you say, so I'm going to sue you to stop you from saying that. McDonald's has a lot of money and very powerful lawyers. You probably don't. So the idea would be that they would bully you with the legal system. The anti-SLAPP is designed around this sort of idea, the abuse of the legal system to prevent other people from speaking. Now, that's the ideal of the anti-SLAPP. How it works in practice in many states is it comes out, in my opinion, to be a bludgeon to stop otherwise meritorious lawsuits through the provisions of the statute, which do things like prevent discovery. People do not have to comply with discovery in these lawsuits in Texas specifically, because the TCPA itself stops discovery the moment the motion is filed. You say, okay, you don't get to find anything else out. Well, now you have to conduct a lawsuit, at least at the initial stages, and gather some evidence at the initial stages to try and support factually your claims that they have lied about you. But think about the problem with this here that we already have. You have to prove the negative. You have to prove that what someone said is not true. You already have a high burden. Anti-SLAPP statutes put a little bit of a higher burden on these types of lawsuits. Some people really like them. I like the concept of anti-SLAPP. I do not think it's applied appropriately. And I think in the age of things like Me Too, that it gets misapplied with regularity, and that people who are actual victims of actual defamation are not able to fight back because the burden of an anti-SLAPP is so high. Now, if you lose an anti-SLAPP motion in Texas, which is what would ultimately happen to Vic Mignogna, not only do you lose your case, but you are then required to pay the reasonable attorney's fees of the other party. So the prospect of bringing a lawsuit is extremely expensive because you have to fund your own legal representation, and you may have to fund a good bit of your opponent's legal representation. And it's dependent on whether or not you can prove sufficient to some judge that this case has merit, but you're not able to call witnesses. You're not able to compel evidence production from any of the parties or any of the non-parties prior to the suit, or once the anti-SLAPP is filed. It becomes very, very difficult. So that said, a TCPA motion was filed, and the fight really kicked off at that point. There was all sorts of motion work that happened back and forth. And in the end, there was a hearing. I attended this hearing in the audience because despite the protestations of really dumb people on Twitter, I am not and have never been on Vic's legal team or in Vic's employment as a lawyer. I'm really, really sorry to say that, but it's not me. I have not been drafting legal documents. I have not been constructing legal arguments. All I have done is what I do with any case that I'm following, and that is cover what happens, talk about different possibilities, talk about different strategies, and see where the show goes, because that's the show that I run. And for me, it's much more profitable than being a lawyer. But that said, Vic would ultimately lose at this hearing. This would have been in mid to late 2019. Dates are fuzzy. Mid to late 2019, he would lose at this hearing, and then he would appeal that decision to the Texas Second Court of Appeals. And then it would take until now, tonight, to get a result. And that's what we're going to go through. So I hope that introduction was Palmyra, can you message me on locals about that, and I'll forward that on, try to figure out what the heck's going on. But with that, I will be bringing up the appeal decision, and we're going to go through again the gist of it, because I think there's some really informative stuff in here for people as to why this thing worked out the way it did. And some of it's probably going to piss people off. That's okay. You can be mad about things. Other parts of it may not make sense. I'll try and help make sense of it. But the frustrating part from my perspective, and this is personal, this is for me, is watching something from the sidelines, not really able to help because that's not your job, and then having people misinterpret or misstate intentionally what you have done or said the entire time. From the beginning of this case, I did say that defamation cases are extremely hard to win. They are. Now, I do think Vic has a winning defamation case, but he did not win. That's been true. I think that he was definitely defamed by these people. I think that the defamation is pretty clear to see. The judges did not see it laid out for them in the way that it works in my head. And you can blame Ty and his firm for that, or you can blame the judges for that, but that's the way that worked out. I still think he has had a winnable defamation case, or what should be a winnable defamation case. I still think that the TCPA puts an onerous burden on plaintiffs that is unreasonable, and I do not like anti-SLAPP statutes. We do not have anti-SLAPP in Minnesota because in Minnesota, we found that the anti-SLAPP statute, our Supreme Court determined that the anti-SLAPP statute forces someone to try a case without a jury and without their rights of discovery. And they didn't like it. Other states disagree. California, Texas, there are a bunch of them that have them at various degrees. But in Minnesota, I agree with the Minnesota Supreme Court, and I think that that is the correct decision, personally. That being said, the other thing I said about this appeal the entire time was do not get your hopes up. Was appeals are the long shot, and it is very unlikely he will win. I've already seen people saying that for the past, which is silly. You can always tell who doesn't watch my show at all because they say for the past 3 years, you've been acting the opposite. It's like, I barely talk about this case at all because there was just nothing happening for so long. But I've barely talked about this case in the past year, really 2 years. But when I do, and because people ask me all the time, was there a Vic update? The answer was no, but also like appeals not looking, they're not winners usually. But I did, even I felt a little bit of a victim to the hype. I got my hopes up a little bit with some of the decisions that came out, and I got my hopes up with how long it was taking and following some of those decisions, which is too bad. But that's why it's easy for people to fall into this, because you start thinking about all this other stuff. It's like, oh, okay, must be, maybe things are going well, maybe things are going right, but they're not always doing that. So anyway, let's hit some of these initial super chats, and then we'll go ahead and hit the document, and we'll get straight into it. By the way, you know what I wanted to talk about? It was not this tonight. I did not want to talk about this. What I wanted to talk about tonight was, where the hell are we? There we go. There's a judge in Florida, a Florida federal judge, who is trying to stop a Florida state law about anti-wokeness. That's what I was going to talk about. So we'll probably end up talking about that tomorrow, just in case people are curious. But I found that to be a really interesting topic, and then this thing dropped. So it's like, oh, well, shit. I guess I have to talk about this tonight. There's really not another option than to talk about this. But here we go. Franco Miranda says the Second Court of Appeals had better enlighten us as to why they're ghosting Vic with their citations and reasonings. Will he appeal to the Supreme Court? I don't know what he'll do. I don't think he should, personally. But it's not up to me in any way. But I think the Supreme Court is such a long shot. And reading the decision, I mean, I disagree with some of the kind of conclusions of the decision, but I'm not seeing disagreement that I think is strong on appeal, if that makes sense. So that's my personal opinion. I don't think he should at this point. Look, at the end of the day, Vic is still going to some conventions, and he just landed a new acting and directing gig at a new studio, as announced at Anime Matsuri, and they are producing anime. He's voice acting. He is doing what he wants to do. He's building his career back. So to me, I think the focus there and the focus on his fans is probably the right move. But I'm not him, and I'm not his lawyer, so I couldn't tell him what to do. He probably wouldn't listen to me anyway. Aside from that, welcome back, Nick, and I hope you and Lady had a great vacation. We did. We did. Thank you for the welcome back. Ron Toye the third says, beat that, you grifter. We came victorious. Now I will celebrate this victory by getting pegged by Monica and Jack Murphy. We worked things out. Well, I'm glad you did. It's a beautiful relationship. Mass Cuckoo. I have no idea what the names of the two anime, the OVAs they did. I think they're announcing a full series. And it's like multiple season series that they have, I believe, secured the rights to, but it's not my announcement. So I don't know the like finer details of anything, but they debuted two OVAs this year at Anime Matsuri, but the real work is going to be, on what comes next. So we'll see how that goes. But I don't know the names of any of this stuff. Who? Gator Time says Genbenoho and Zip Shimezo. Who names anime? Like, whoever names anime should be put on a cross. I tried to watch them. Remember my criteria for anime. There were no ninjas or robots in these anime, and there wasn't even any killing from what I understand. So it didn't appeal to me personally, but I know a bunch of little weebs liked it, so they can enjoy that all they want. The upcoming series, I heard some details about it. It is from a major studio that has major production out there as well. Again, it's not my announcement, so I don't know if it's even been publicly announced or whatever, but it sounds cool. It sounds like something I would actually watch. Palmyra Productions, email me. I'll forward them right to my locals person. We'll get you squared away. All right. Okay. You assumed it was a lolly and gross? No, I don't think so. And Martin says they were cute, family-friendly shorts, which I think shorts are like 40 minutes or something like that in this case. But yeah, again, lots of people liked them. They just weren't my style of anime, so I didn't care about it. That being said, let's the thing that they're coming up with, or that they've got next, seems awesome. So I'm actually pumped to see that come out. Doozy says an old school drunken lawyer reads papers and yells at chat stream. Finally. Also, if anyone likes lo-fi or Cowboy Bebop, I just put out a lo-fi version of the Cowboy Bebop theme on Spotify under the artist name J Deuce. Comes out at midnight, and thanks. Hey, very cool. Check that out, guys. If you like Cowboy Bebop or lo-fi music, or Cowboy Bebop and lo-fi music, midnight, J Deuce. Deuce as in poop. Sam Welter says, give a toast to our boy Vic and his gay pants. I will. To my friend Vic Mignogna. Who have not spoken with yet, but I am sure is not having the greatest evening. He will always have my faith and support, unless I were to find out at any point that any of this was true. And the amazing thing is, in the 3 years I have been able to get to know him and his character and talk to the people who are in his lives, I've not found any of this to be true. And that's the most fucking frustrating part of all of it. So to a man whose name has been maligned, misrepresented, and misandried by fat, unhappy people, to a man who through all of that, stayed relatively cool, polite, and professional, and all he ever asked was just to be able to talk to his fans, to meet them, and continue bringing a great experience, all while wearing the absolute gayest fucking pants I have ever seen, with more laces, chains, zippers, and homosexuality in them than anything else on earth. To Vic, buddy, I'm sorry that things did not work out as they should have, but I hope the future holds much brighter things for you, brother. All right. A Lonely Crow says, Nick, I can't stay for the show, but can I get a toast for my West Nile sticker? I've had it on my car forever, and I'm sad that it is peeling off my window. Wish you still sold the design, but I still have the shirt. I'll have to check. I probably still have the design. A toast to your West Nile sticker. Though it leaves whatever you had it on your car, I guess. Though it may be leaving your car, the one place West Nile will never leave is J. Sean Lemoyne's crippled, AIDS-riddled lung. May it rest in peace there forever. Mo says, hey, Nick, I have a conundrum only a lawyer of your stature can answer. Given the following two options, which one would you choose? A, get pegged, or B, get cucked? Thanks. I was going to say a thing that would violate YouTube's terms of service. So let's just say this. In Minecraft. How's that? We'll just go with in Minecraft as the answer. Thank you. Slosher says, need advice, please. I have a few far left friends reaching out for the first time in 2 years. Never cared about any friends' politics, but the way some acted the last 2 years makes me question that. Can you trust a socialist? Yes. Of course you can. You can always trust a socialist to be a socialist. They will always do socialism. They will default towards government provision of whatever they believe they need. And they will always think that they will be on the upper tier of socialism, making the decisions about who gets what, not in the lower tier of socialism where the other people get decided that they get their stuff and you don't. So yes, you can trust that. But what I'd say about that is simple. Look, you can be friends with a lot of people. And their politics will come up from time to time. And you can decide whether or not it's worth fighting with them over it or just being friends with them. But a lot of people with shit like politics compared to yours make shit friends. Not all of them, just a lot do. So find the ones that don't. That's the simple thing. And a lot of people with or less so probably, but a lot of people who have matching politics with you also make shit friends. So don't hang out with shit people. If they're good people, their politics may change over time. If they're shit people, just ignore them. Blaine's Escape Corner. Read the short letter from the court on stream earlier. Interested in hearing a lawyer read it. Keep up the positive. I had to bankrupt a business and still have another venture working. You can lose and still find victories. You absolutely can. Absolutely. And I hope there are many more victories in Vic's future than these losses. But you got to face what they are. I mean, they are losses. They're really fucking annoying setbacks. They will allow many people to gloat all over the place, and that's just what's going to happen. There's no way around that. Casey, I went on a date with a 10 and talking to me anymore. And she's not talking to me anymore. Feeling very depressed. Am I just being gay with all these feelings? Yes. Yeah. You went on a date with a 10. I mean, you think that was going to work out? Are you a 10? Like, are you a 10? Are you a rich millionaire with a 12-inch penis? No, you're not a 10. So like you got your shot. You got to hang out with a hot chick for a while. In the end, probably was going to piss you off anyway. All right. But don't be depressed. Maybe she's just busy, right? Like with all the other dates that she had lined up prior to the one date with you. She had to fill those appointments, Now she's got to fulfill those appointments, and then she can get back around to you or whatever. I'm just kidding. Who knows? Women are so fucking weird about everything. So don't worry about it. But you can't be depressed. You got a date with a 10. That means you did one thing right at least for a while. Now do that to like an 8 and go live happily ever after. King Dude says, conductor, we have a problem. 1, 2, 3, 4, 5, 6, 7. 7 times, I think. Okay. And then Sinrius Akari says, those other voice actors are on borrowed time at the rate they are unionizing. We're sticking by Vic regardless, and this changes nothing. And I mean, at the end of the day, that's what there is to do. Like, does this outcome change your perspective on Vic? And if it does, it probably shouldn't, because yet again, we will see the court punt the ball on addressing the merits of the case, which is the most fucking frustrating part of all of this pretrial dismissal shit that happens. And it runs completely counter to the narrative that fatzos like Monica Rial and Jamie Markey have said the whole time, where they're like, they say we just want the truth to come out. But what they did the entire time was file motions to prevent any truth from ever coming out. They never had to go on the stand to answer for anything. They never had to have other witnesses come in and contradict their stories. All of that would have happened at a trial. And that trial will never occur because the people who, quote unquote, wanted the truth to come out actively worked to keep it from ever being heard. The Anime Collector. Hey, man, it's been a long time. Says, seems kind of crummy of the appeals court to jerk Vic around for an eternity while the fees accrued interest. At this point, what does Vic have to lose appealing to the Supreme Court? More fees, assuming we blow up that GoFundMe to cover it. That is more fees, but I don't know. Like, if people wanted to donate to the GoFundMe, they could. I don't know that I'd be the one to promote it, though, because I see big problems bringing it to the Supreme Court, or not really big problems. I'm not sure it's the right move personally. So, but I don't know. We'll see how it goes. But yeah, more fees, and lots of them going to the Supreme Court. It would add significant cost. Kelly Forgy says, may I ask for a toast and a prayer? My aunt, friend, and drinking buddy is on the losing end of a sudden battle versus an aggressive brain cancer. She's leaving behind a husband, 2 kids, and 2 grandkids. We're losing a real one. Yes, you can. Kelly. To Kelly's friend, a reminder that the concerns about money and reputation in this world they're important, but they're concerns over things that exist while we have life left in our bodies and while we do not leave friends and family behind. I don't know her friend, of course, but she sounds like quite a woman. In a committed relationship, a marriage with children, and thinking of those bonds is of course sad, but I pray that her family will be motivated and resolved by the woman she has been, and the woman she has been through this trauma and through this very, very sudden change. May her memories always be at the forefront of their minds and always pleasant. And may the lessons she taught them inspire them to teach the next generation to be better people than they are in her image. Cheers. All right. Elite Neo says, sucks Vic's appeal ended this way, but at least he's still got his gig with Anime Matsuri's studio and all his fans who love him. He'll be okay. Plus, now everyone knows what pieces of garbage Ron, Monica, Jamie, etc. truly are. And then Sublime and Slime says, lost my Discord account and server of 6,000 that I and other Jannies spent time building for supporting Trump, and don't like the use of combs on children by alphabet people. Find us on r/ask_the_Donald on Reddit now. New server, same people. Link there. Well, there you go. And get it while it's hot, because I'm sure that'll get banned too pretty quickly. Okay, let's do this. Let's get into the document. So this is the memorandum opinion. This is the full opinion of the court itself. It was penned by which one? Wallach. Wallach is the judge who penned the opinion. Joe Schmo, 1 of 3, says, "Hey, Nick, buy some $20 ice bags to drown the taste out of those military special jugs." Oh, disgusting. Gross. Gross. Thank you. Okay, here we go. The Texas Citizens Participation Act is an anti-SLAPP statute intended to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, at the same time protect the rights of a person to file meritorious lawsuits for demonstrable injury. I mean, again, looks like a meritorious lawsuit for demonstrable injury for me, but it's all in how it plays out in court, as we'll find. Here we go. The TCPA was intended to provide protection for the involvement of citizens in the exchange of ideas. To that end, the TCPA provides a procedural mechanism for dismissal of lawsuits that could unjustifiably interfere with these rights. Under the TCPA, the first step in the statutory burden shifting analysis is for a defendant movement to show by a preponderance of the evidence that the plaintiff's claim is based on, relates to, or is in response to the movement's exercise of the rights of free speech, of association, or petition. So the first thing is that you sue someone, right? And then they move for the anti-SLAPP. So they are the movant. They have to prove that what they did was within their rights of free speech, free association, or the right to petition. Most things that you do are within these rights, right? Like if I say something to you, I'm exercising my right of free speech. If I hang out with you, I'm exercising my right of association. So long as there are a couple people involved, you pretty much nailed this. Posting on Twitter, for example, probably exercising your right of free speech and association. Even though there's this weird conundrum where we've determined that you have no free speech on Twitter, it is still considered an exercise of your free speech rights to post on Twitter. The law is weird and fuckery is afoot. The Anime Collector with another donation. Hey, thanks, buddy. Says, "I think I speak for everyone here when I say that we'd blow up that GoFundMe at the drop of the hat. Just take this battle to its dying breath. Losing at the Supreme Court would mean nothing at this point, but winning there would mean everything." Again, it's up to Vic. I can't make that decision or determination at this point in time. All right, so here we go. If the defendant movement satisfies its burden, then to avoid dismissal, the plaintiff, non-movement, in this case Vic, must establish, quote, "by clear and specific evidence," which isn't actually a thing, "a prima facie, on the face of it, case for each essential element of the claim in question." If the non-movement satisfies its clear and specific prima facie burden, the movement may still have the claims dismissed by establishing each element of a valid defense to the claims. The application of this structured burden-shifting analysis controls this case. Appellant Victor Mignogna sued appellees Monica Rial, Ronald Toye, Jamie Markey, and Funimation Productions for defamation, conspiracy, tortious interference with existing contracts, tortious interference with prospective business relations, and, as to Funimation, vicarious liability for Rial, Toye, and Markey's actions based on their postings on Twitter. Appellees moved to dismiss Mignogna's claims under the TCPA, and the trial court granted their motions. At a subsequent hearing, the trial court ordered Mignogna to pay litigation expenses and attorney's fees and impose sanctions. The TCPA requires it. That's what this basically says. It requires the fee shifting that occurs. In 8 points, Mignogna appeals, claiming that the trial court erred by finding that appellees' evidence was legally and factually sufficient to satisfy their TCPA first step burden based on their evidence's lack of admissibility, by dismissing his claims, by refusing to consider his second amended petition. This is the critical one, by the way, in my opinion, and by ordering him to pay sanctions and attorney's fees. And I really do. I would suggest that this is the death knell to the rest, because as we've discussed in the past, the original complaint had some issues. The first amended complaint didn't remedy them. The second amended complaint did. Or amended petition, I should say. It, in my opinion, did remedy many of the issues that are involved here. It more clearly laid out the timeline and directly linked them to direct statements from the defendants and actions. It also included 3 affidavits, well, technically unsworn declarations. Those were never read by the court and not considered, and those contained critical evidence about what had happened. Without having those, it was a long shot to victory. All right. On the record before us, appellees meet their initial TCPA burden in part because Mignogna failed to preserve his complaints about their evidence, which the trial court considered along with Mignogna's allegations in his first amended petition. Stating that in determining whether the TCPA applies, the court initially looks to the plaintiff's allegations. And because Mignogna withdrew the principal evidence supporting his prima facie burden before the hearing on appellee's TCPA motions, he was unable to make his TCPA burden on any of appellee's claims. So what this is referring to is that there were initially 3 sworn affidavits, 3 notarized affidavits, Chris Slatosh, Vic Mignogna, and Chuck Huber. Those affidavits were notarized in error. I believe this was on the record at the court, and they were withdrawn due to defects in the notary, defects in form. They were replaced, which would normally not be an issue, with unsworn declarations from the same 3 people that were factually or that were effectively identical documents. Those were attached to the second amended petition. However, since the court did not consider the second amended petition, it did not consider the 3 unsworn declarations. And since the affidavits were withdrawn, those were not considered as well. This is a big problem with what happened. We'll get to why the court did not consider the second amended petition. It's the one part of this that I really have trouble with, but it's the court's ruling. So with that, accordingly, the trial court did not err by granting appellee's TCPA motions, by imposing sanctions, or by awarding attorney's fees. We affirm this portion of the trial court's judgment. On cross appeal, they complained the trial court should have awarded them the full amount of attorney's fees they requested. Because we hold that the trial court's order on attorney's fees is against the great weight and preponderance of the evidence, we reverse this portion of the trial court's judgment and remand the case to the trial court on that issue. So this will go back on the attorney's fees, and each side will get to, in some way, litigate on the facts of the attorney's fees and whether or not they are reasonable. Monica's team will, of course, ask for more fees. Vic's team will try and counter that, and we'll see how that goes down. The implication here is that they're likely to get more fees than they were originally awarded. Whether or not that matters in the end, because whether or not those fees are getting paid is a completely different question. It's one thing to be awarded something. It's an entirely different thing to collect on a judgment. But all of that remains to be seen. Here's the factual background. For more than a decade, Mignogna, Rial, and Markey worked as anime voice actors for Funimation, appeared together at fan conventions. During that time, various rumors about Mignogna's behavior had circulated to the point that he held a rumor panel at a 2010 fan convention to try and dispel them. This is a little bit of a stretch, but okay. Remember, they're pulling these from the petitions. They borrow this type of language from the factual basis in the petitions. More rumors resurfaced on January 16, 2019, the same day that Funimation's major anime film starring Mignogna's voice in the lead debuted. That day, someone with the Twitter handle Hanleia tweeted, "Hey, Funimation, why do you employ a known pedophile?" with a link to allegations of sexual misconduct by Mignogna at anime conventions. Another person with the Twitter handle Actually Amelia tweeted, "How is Vic still working in anime? Every time Assault and Fandom comes up in a conversation, no matter who I talk to, so does his name. Every time. At some point, an open secret becomes common knowledge and inaction becomes inexcusable." Interestingly, of course, none of these allegations have ever panned out. There's no allegation from an actual victim other than Monica Rial or Jamie Markey of Vic Mignogna. And there's never once been a single police report. There are no convention reports that have ever been produced that back up any of this stuff at all. It's all just conjecture. But that's the way this goes. All right. Mignogna did not sue Hanlea or actually Amelia. I mean, these two people have literally nothing to take. Or any of the online magazines covering the allegations, Polygon, Anime News Network, and Gizmodo, for defamation. Instead, after meeting online with his fan club and encouraging them to speak of their positive experiences with him, Mignogna posted a tweet on January 20th, issuing what he characterized as a generic apology for unintentionally offending anyone. This is one of those, fucking hell, one of those things that should never have happened. This is a thing that should not have occurred. This unintentional offending anyone, this apology bullshit. If you ever want to know why I say never apologize, this is why you do not fucking apologize. Don't do it. Don't do it. It will not help you. Funimation, its parent company, began an investigation and terminated Mignogna's contract on January 29th. Again, one of the facts that was not allowed to come out of this case is that the investigation into the allegations had nothing to do with any of the allegations that were actually made. The investigation conducted by Funimation involved 3 separate instances. First, that Vic Mignogna walked into Funimation Studios, went into the room of an employee, and kissed her. Now, Vic has talked about this. This is a person whom he had taken on several dates, had extensive conversations with, and asked permission to kiss her for a year. This person is also not the person who made the complaint to Funimation, and Funimation did not interview said person, who is no longer at the company. Instead, Funimation asked Monica Rial about this event that she was not present at. That was step 1 of the investigation. Step 2 of the investigation was an allegation about 2 twins that Vic Mignogna allegedly propositioned for some sort of adult fun time. These were adult twins who had spent 5 straight conventions going to visit Vic, and in the intervening time had emailed Vic pictures of themselves dressed in either cosplay or other clothing that said things like, "We love you, we can't wait to see you," etc., etc. When they came to visit him at a convention, he invited them to his room. They came to his room. When he said, "Hey, were you looking to do anything?" They said no, and he said, "Okay, well then that's cool, you can leave then." And that was the end of it. This, of course, was also not reported by the 2 fans, nor were they interviewed by Funimation. Instead, Monica Rial was interviewed about this instance. And the third allegation that was investigated by Funimation, this is according to Funimation, but the third allegation investigated by Funimation was Vic was sitting at a convention table next to Monica Rial. They both had their artist tables. And on her table was a bowl of jelly beans, or on Vic's table was a bowl of jelly beans. I think it was on one of them, had a bowl of jelly beans. Monica Rial took the jelly bean from the bowl, signed her name or initials on it. It's a jelly bean, so I imagine just her initials, because even those are fat. And then she threw the bean to Vic Mignogna. When he got the Sharpie signed jelly bean, he promptly put it in his mouth and ate it. When someone freaked out and said, "Aren't you worried you'll get sick from the Sharpie ink?" he said, "No, because at least I can say I've eaten Monica Rial." That apparently right there was years later determined to be a sexually harassing statement by Monica Rial, and she would talk about that with Funimation. Those are the 3 instances that were investigated by Funimation, and that was sufficient for his termination. The allegations made online, the allegations that were made online by Monica Rial and Jamie Markey were not part of Funimation's investigation, nor were they investigated, nor were they the basis of his termination, ever. But of course, this is one of those facts that could have come out at trial with discovery, but the TCPA shuts down discovery. So there you go. That's that. Funimation commented about Mignogna's termination in a tweet on February 11th. During the Mignogna-related social media maelstrom between January and February 2019, Rial Markey and Rial's fiancée Toye published some tweets, like 400 tweets, as did Mignogna, like 4 tweets, whose fans paid into a GoFundMe account, Vic Kicks Back, set up by Nick Rekieta on February 19th to cover Mignogna's litigation expenses. That's true. There you go. Hey, I'm in the document. Mignogna sued Funimation, Rial, Toye, and Markey in April of 2019. Is it what? By the time the attorney's fees hearing in November 2019, Mignogna's GoFundMe account contained $261,700. Okay, that's the footnote. I wanted to see what the footnote was. So the procedural complaints. Did they misspell my name? They did. Even a court can't do it. You look for competence in the legal system and you never fucking find it. R.I.P. to me. Fucking hell. You know, all I want is a little recognition. All right. Procedural complaints. We begin with Mignogna's procedural complaints because they are dispositive of his appeal. So the procedural complaints are what we'll do it in. And this is going to be, again, the main thing is going to be that second amended petition. Would the second amended petition have gotten him through the appeal? We don't know. But there's a pretty clear indication that it would have gone a little bit better. All right. We review most procedural complaints for an abuse of discretion. A trial court abuses its discretion if it acts without reference to any guiding rules or principles. That is, if its act is arbitrary or unreasonable. Court's failure to analyze or apply the law correctly is an abuse of discretion. The abuse of discretion standard governs amended petitions and evidentiary rulings. In contrast, a trial court generally has a ministerial duty to enforce a Rule 11 agreement once it exercises its discretion to determine the agreement's validity. And this is where I will disagree with the court a little bit. I still do not believe that the second amended petition is covered in any way by the Rule 11 agreement. And I think that to state that it is an error. This is my big problem with this appeal decision right here. It was also the main thing I focused on was this second amended petition. I mean, I thought that's the most critical issue. And I do not think it's within the Rule 11 agreement. The court will disagree with me here. So where there is a valid Rule 11 agreement that is not subject to any exception, such as fraud or mistake, the trial court has a ministerial duty to enforce its terms. So Mignogna's late filed second amended petition. In his 6th point, Mignogna argues that the trial court erred by not considering his second amended petition and its attachments in deciding whether he had met his burden to defeat Appellee's TCPA motions. Again, personally, this would have been my first point of appeal and would have had the most time devoted to it. Because I think it's the most important. I think the court agrees that it's the most important point, which is why they raise it first. Funimation filed its TCPA motion on July 1st, 2019. Rial, Toye, and Markey filed theirs on July 19th. The motions were originally set for hearing on August 8th, but the parties agreed to move the hearing to September 6th to allow Mignogna more time to respond. On August 6th, the parties signed a Rule 11 agreement wherein they agreed that Mignogna would file his response to the TCPA motion by August 30th. See Texas Rule of Civil Procedure 11. So Rule 11 simply states that within a lawsuit, parties can basically contract, following the rules of contract, they can agree to just about anything. They can make an agreement between parties, and that agreement becomes enforceable by the judge. So in this case, they said, you know, we want more time to file. We'll file by August 30th, the response to the TCPA motion, and that'll be the end of it. And everybody agreed to that. That's the Rule 11 agreement. According to the subsequently filed plaintiff's motion for leave to file late response to defendant's TCPA motions to dismiss due to technical issues, Mignogna's counsel unsuccessfully attempted to file Mignogna's TCPA response just after midnight on Saturday, August 31st. He successfully served Marchi's counsel, however, who asked him to provide a certified copy of all notary book pages for the notarizations performed by him on August 30th, the date that the affidavits of Mignogna, Chuck Huber, and Christopher Slatosh, which were attached to Mignogna's TCPA response, were signed according to Mignogna's counsel's notary stamp. At 9:04 a.m. on September 2nd, Real and Toya's counsel asked Mignogna's for an explanation of how Mignogna, Huber, and Slatosh could have signed their affidavits in his presence when none of them were in Tyler with him on August 30th. Mignogna's counsel successfully filed the TCPA response at midnight on September 3rd, the day after Labor Day, along with a motion for leave to file a late response due to technical issues. In addition to the 3 affidavits described above, Mignogna's counsel attached to the TCPA motion the depositions of Mignogna, Real, and Toye, along with 342 tweets that were attached as exhibits to Toye's deposition, the unsworn declaration of E.M., a convention representative who wrote the declaration in response to statements about her by the CEO of Kauai Con Convention, whose affidavit was attached to Real and Toye's TCPA motion, and an affidavit by Stan Dolan regarding his recollection, none, of an incident involving Mignogna that Real had described as having occurred at the November 2007 AzumiCon, a total of 8 exhibits. All right. So there was a technical issue. We talked about this when it happened. There was a technical issue in which the response was delayed by like an hour or something like that. And everything was filed. It says his counsel filed the TCPA response at midnight on September 3rd. It's not entirely accurate. It was filed right away on September 1st, just after midnight. But the way the Texas filing system labels things, it labels them as coming in when the system comes online on the next Monday. But that being said, let's see. Okay. Yeah. So here's what it says. As pointed out by Real and Toye's appellate counsel, although Mignogna's counsel informed the trial court that his TCPA response was late because of technical issues, the response itself was rife with missing citations, incomplete arguments, and other errors. And that was not a great document, by the way. Not a great document at all. He simultaneously filed a second amended petition containing 20 new paragraphs of factual allegations. To the second amended petition, he attached 17 exhibits, which he described as prima facie evidence sufficient to prove each element of each claim, and referenced the exhibits in 18 of the petition's paragraphs. 9 of the 17 exhibits contained evidence that was not attached to the TCPA response. The remaining 8 exhibits consisted of 3 unsworn declarations, Mignogna, Huber, and Slatosh, with the same contents as their affidavits, the 3 depositions, EM's unsworn declaration, and Dolan's affidavits. So that was the attempt to file the second amended petition. 45 minutes after filing a TCPA response and second amended petition, Mignogna's counsel replied to opposing counsel's September 2nd affidavit inquiry, stating that he would withdraw the 3 affidavits and that they had been mistakenly submitted with defects in form. He filed a notice of withdrawal of the affidavits around half an hour later. At the TCPA hearing on September 6th, his counsel stated that he had filed the second amended petition after opposing counsel notified him of the defective affidavits. I don't remember this, but I'll take their word for it. Appellees objected to Mignogna's late filing of his TCPA response, the filing of his second amended petition, the attempted late submission of evidence, citing surprise in their mutually agreed August 30 deadline. Now, importantly, the August 30th deadline was literally for the TCPA response, according to the Rule 11 agreement. And this is where my big disagreement comes in with the Court of Appeals here. The Rule 11 agreement does not cover any submissions of evidence or of the second amended petition. It's literally the TCPA response itself. And what the court will do here is say that these things are this, even though this is a different thing than those things. Ambulance changer says, "You forget, huh? How convenient." Yes, it was literally 3 years ago, and I do not remember that specific thing being said in court. Whether or not he said that he filed it after they notified him of the defective affidavits. I do not remember if that was specifically said. I don't remember it, but it said also that I'll take the court's word for it. I'm not disagreeing. I just don't remember that. And I would be surprised if you would. But okay. Was Ty slacking, or is this normal mistakes? I would not call these normal mistakes. I don't know that Ty was slacking or not, but I'm not here to defend Ty Beard or speak on behalf of his firm. If he wants to do that, that's up to him. Like I'm here to talk about what happened here in this document and to call out bad things when they're bad and good things when they're good. I said the TCPA response was a mess. It was really bad. But I also believe that the second amended petition was a good document, and I believe that the second amended petition is outside of the Rule 11 agreement. So I think they got hosed on that. I think they got hosed on it in the courthouse as well. But I mean, the court doesn't agree. So that's my opinion there. Funimation also argued that under Rules of Civil Procedure 59, Mignogna could not attempt to meet his evidentiary burden by attaching evidence to a second amended petition. So then they've got citations that they put in here, allowing parties to only make certain items, notes, accounts, bonds, mortgage records, and all their written instruments constituting in whole or in part a claim or defense, part of the pleadings by attaching them to the petition or answer. But I mean, all of the written incidents constituting in whole or in part a claim or defense. I mean, the argument that was made in court was that these were written instruments. The judge was skeptical, saying that the instruments used here was a more technical term of an instrument, like a financial document. Whatever that means doesn't matter because it wasn't actually considered. The second amended petition was not there. Reviewing TCPA non-movements, live pleadings, and exhibits incorporated therein when movements failed to object. Okay, I'm not sure why that's there, but all right. In the ruling on the TCPA motions, the trial court granted Mignogna's motion to late file the TCPA response and deemed it timely filed, but stated that because Mignogna had withdrawn the 3 affidavits, it did not consider them or any evidence attached to the second amended petition. And this is the death knell right there. It didn't consider the 3 affidavits or any evidence attached to the second amended petition. And without that evidence, you weren't going to present evidence that you had been defamed. Like that just wasn't going to happen. Mignogna's remaining TCPA evidence consisted of the depositions, which in my opinion actually should have been sufficient, EM's declaration, and Dahlin's affidavit. The record reflects that Mignogna essentially, see, this I don't agree with personally. I don't think the record actually reflects this, but again, the court can disagree with me. That's fine. They get to win. Essentially tried to use an amended pleading as a late TCPA response to remedy his lack of evidence and thereby avoid the parties' Rule 11 agreement deadline. I don't think this is true at all. I think that a Rule 11 agreement on filing a TCPA response is one thing. I think a second amended petition is a completely different thing. But that's my personal opinion. The trial court has a ministerial duty to enforce a valid Rule 11 agreement, and Mignogna did not argue in the trial court or in this appeal that the parties' Rule 11 agreement setting a deadline for the TCPA response and therefore evidence was invalid. See, this and therefore evidence isn't part of the Rule 11 agreement. The TCPA response is in the 11 agreement, and therefore evidence. I would disagree that that's part of the Rule 11 agreement. I don't think so. The court reads that in, but it's not in the express terms of the Rule 11 agreement. see, where do I have that? I don't know if I have that anymore. I don't know. I haven't looked at all this stuff in so long. I don't know where the fucking I don't even know where that would be. Gosh. I'll have to try and find that, but I do not remember the Rule 11 agreement covering any other evidence or anything like that. It was pretty limited, if I remember right, specifically to the TCPA response, and it was express. Rage DMX 47 says testify. Okay. What am I testifying to? And then let's see, Mr. Armageddon says this is a complete loss, at least legally. Do you still think Vic made the right choice? Is Vic better off now? Yes. I still think Vic is better off than when he started all of this. Yes. However, I would hope that he would be in a better off place than he is now. Outcome bias is a real thing. Let's hope the benefits outweigh the costs. I stand with Vic. You'll never know, right? Like, who knows what would have happened if he had not filed the lawsuit. I think it was the right move, but you're right. Outcome bias is a real thing. He lost. That sucks. Does that mean that the fight, he shouldn't have had it? I don't know about that. Let's see. Accordingly, we hold that the trial court did not abuse its discretion by refusing to consider Mignogna's second amended petition and attachments filed in violation of the Rule 11 agreement. Again, I have a hard time saying they're filed in violation of the Rule 11 agreement. This is my main disagreement. An easy pawn, the parties entered a Rule 11 agreement whereby the defendant agreed to delay the hearing on its motion to compel so long as the plaintiff filed his response at the motion at least 1 week before the hearing. Plaintiff did not file his response until 1 day before the hearing, and the defendant sought to enforce the Rule 11 agreement at the hearing. The Supreme Court held that neither the trial court nor the Court of Appeals should have considered an affidavit filed in violation of the Rule 11 agreement. But see, this is a different case where the exact thing that was supposed to happen or wasn't supposed to happen did happen. Citing easy pawn for the proposition that when affidavits are filed late in violation of a Rule 11 agreement on deadlines and the opposing party seeks enforcement of the agreement in trial court, neither the trial court nor the Court of Appeals can consider the affidavits. Because the trial court did not abuse its discretion by excluding Mignogna's second amended petition as being in violation of the party's Rule 11 agreement, we need not address Mignogna's alleged Rule 59 violation. We overrule Mignogna's 6th point. So this was the 59 violation that's alleged, is that he couldn't attach those documents to the second amended complaint as well. So the big issues here, the bad notaries on the affidavits, huge issue, big problem, really should not have occurred at all. Whether or not those would have saved it, I don't know. Because remember, the TCPA response was not a good document. The second amended petition was a better document all around for the whole case. Second amended petition would have been great as the original complaint. However, I think the second amended petition had a lot of information that had come up after the initial filing as well. So I'm not saying that it could have been written in the same way at the beginning, but just it should have been the operative document. It would have been a better document than anything else. But c'est la vie. That's not the way it worked out. And is that on Ty? Maybe. Maybe it is. I don't know who else it would be on in this case. The notary thing's a big problem. And then the inability to get that second amended petition on. While I disagree with the court's reasoning on the Rule 11 agreement, the solution would have just been to have that second amended petition filed prior to August 30th. Could they have done it? I don't know. I'm not in their office. Why it took to the point that it took, I have no idea. I have no idea why anything happened the way it did. What I do know is that the way it happened is a big part of why this didn't work out. At least at this point. Had it gone past this, we don't know what would have happened. Had that part of the analysis been different, we don't know that he still would have passed appeal. But it seems like he would have had a better shot. Can they file for reconsideration? Yes, they can. Wasn't there a recent law change in Texas? I don't know. There was substantive law change in Texas. If I were going to file reconsideration on this, this is where I would focus. I would focus on that Rule 11 agreement personally, because I do think it's the critical element of the case. What I think would happen if you file for reconsideration on that Rule 11 agreement and try and get the second amended petition in, they'll say, okay, the second amended petition comes in, but it's a violation of Rule 59 and those affidavits can't be attached, and therefore there's still insufficient evidence. I think that's how it would go, personally. Does that mean you shouldn't try? No. But I think that's the outcome. Oh, you've got a link to the Rule 11 agreement in my DMs. Let's see what it says. All right, here we go. Here's the Rule 11 agreement in full. All right. So, counsel, under Rule 11 of the Texas Rules of Civil Procedure, this will confirm our agreement regarding scheduling matters related to defendant's motion to dismiss under the TCPA. Parties agree to the following. Plaintiff will file his responses to the TCPA motions and any objections/motions to strike on or before August 30th. Defendant will file their replies and any evidentiary objections in support of their TCPA motions and any objections/motions to strike on or before September 3rd, 2019. Hearings for defendant's motions to dismiss and any party's objections, motion to strikes, to the extent the court determines that it needs to hear arguments on any party's objections/motions to strike, are set for September 6, 2019 at 10 a.m. Plaintiff and Funimation agree that the 60-day TCPA hearing deadline for Funimation is extended to September 6, 2019. Plaintiff agrees that the hearing on the plaintiff's motion to strike that is currently set for August 8th has been moved to September 6th, as stated above. Please execute this agreement and email a copy back to me. That's it. Again, to me, that's a pretty explicit and express contract that does not say anything at all about amended petitions or further evidence. So, again, personally, I don't think the court's right on that, but the court and their citation doesn't have anything to do with incorporating other things into a contract, but the express terms of the contract don't cover that. So, okay. Haywig says you have to argue under abuse of discretion standards, so you lose. Right. Yeah, I guess. Although there's no legal basis to include it in the agreement other than we said so. But that's that. There you go. The trial court's evidentiary rulings. In his seventh point, Mignogna enrobes his TCPA sufficiency complaint about Appellee's motions within his argument that the trial court should have struck Funimation, Real, and Toya's evidence. However, he ignores that in her TCPA motion, Markey incorporated and adopted by reference all the evidence attached by Funimation and by Real and Toya to their respective TCPA motions to prove Mignogna's status as a public figure and that their respective statements were made on a matter of public concern. Mignogna did not object to Markey's evidence or to her incorporation, that adoption of the other party's evidence, and he does not complain about Markey's evidence on appeal. So I guess because he objected to it there, but not in the other place, then it doesn't count. Then he didn't object, I guess. Okay. That is, Mignogna argues that the trial court considered inadmissible evidence in determining that he was a public figure and in determining that Funimation, Real, and Toya's tweets related to a public controversy under the TCPA, including in definition matter of public concern for purposes of TCPA applicability, that an issue relates to a public figure. Again, I think the public figure doctrine is garbage, but I think Vic being a public figure is not the hardest case to make. under the law. I don't think he should be a public figure, but he seems to be one. Hey, what's up, Good Logic? How you doing, brother? Welcome to the Good Logic viewers. Because Markey's evidence and Mignogna's own evidence generally establishes public figure status and the matters of public concern, the error, if any, was harmless. We overrule Mignogna's seventh point without reaching the merits of his evidentiary arguments. Because Mignogna raises no other challenge to whether appellees met their initial TCPA burden, we consider that burden established for our analysis. And of course, they met their initial TCPA burden. To me, that was a foregone conclusion anyway. You're almost never going to show that it's not an exercise of your right to free speech and free association. That's like almost never going to win. Let's see. Beyond his evidentiary complaints in his seventh point, Mignogna does not challenge the applicability of the TCPA to his defamation claim based on appellee's statements. As pointed out by Real and Toya in their appellate brief, Mignogna's brief barely mentions step one of the TCPA analysis, presumably because his petition, together with the evidence and affidavit, show unequivocally that he sued appellees for engaging in two prongs of protected communications, the right to associate and speak freely. I mean, I disagree with that point. The record reflects that the TCPA applies to appellee's statements in that all of the statements of which Mignogna complained in his first amended petition were made in a public forum, Twitter, to the anime community and other voice actors about matters of health and safety. Mignogna's alleged inappropriate sexual behavior with fans, including underage fans, convention workers, and voice actors as part of a public discussion involving the anime and voice actor community. Again, I don't think there was any way you're going to get around the public figure doctrine. I think public figure doctrine is too broad and generally is unconstitutional. But I mean, they made the statements in public. They're talking about this issue. He responded to the issue, something he should not have done. And unfortunately, that's the way it's going to go. Kai says, so Vic was accused of what exactly? That's a really, really tough question to answer. It's a really tough question to answer. Like, what exactly is he accused of? I don't really know. The statements, the tweets were that he assaulted at least 4 up to hundreds of women. That he assaulted them. That's the tweets by like Ron Toye and Monica Rial. Whatever that assault means. It's never really fleshed out. So TCPA analysis in his first, second, third, fourth, and fifth points, Mignogna argues that he met his burden to establish a prima facie case for each essential element of his claims. We reviewed de novo trial court's ruling on the motion. In our review, we considered the pleadings and supporting and opposing affidavits stating the facts on which the liability is based. Regarding the non-movement's burden to establish by clear and specific evidence for each essential element of his claim, prima facie case is given its traditional legal meaning, which is evidence sufficient as a matter of law to establish a given fact if it is not rebutted or contradicted. It is the minimum quantum of evidence necessary to support a rational inference that the allegation or fact is true. Okay. Clear and specific evidence is not defined by either the TCPA or the common law, but our sister court has aptly summarized it as follows. Proof by clear and specific evidence is not simply fair notice of a claim. Rather, under the clear and specific evidence standard, a plaintiff must provide enough detail to show the factual basis for the plaintiff's claim. This is not an elevated standard, does not categorically reject circumstantial evidence, and does not impose a higher burden of proof than that required for the plaintiff at trial. So there you go. Conclusory statements and speculative evidence, however, will not support the non-movement's burden. Fine. TCPA does not forbid using circumstantial evidence or rational inferences to establish a prima facie case, but an inference is not reasonable if it is premised on mere suspicion or if it is susceptible to multiple equally probable inferences requiring the fact finder to guess to reach a conclusion. So here's the defamation elements. Defamation elements are publication of a false statement of fact to a third party. That was defamatory concerning the plaintiff, with the requisite degree of fault, at least amounting to negligence and damages in some cases. A defamatory statement is one that tends to harm the reputation of another as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. And if you don't think that that happened, I don't know what to tell you. Those statements were definitely made. A defamatory statement must proximately cause damages unless the statement is defamatory per se. The statement is defamatory per se if it accuses someone of a crime or of having a foul or loathsome disease or of engaging in serious sexual misconduct. Whether a statement is defamatory per se is generally a legal question. Statements of opinion about a public figure on matters of public concern are not actionable as defamation because they cannot be proved false. Calling someone a sexual predator falls within the broader principle that a speaker's individual judgment that rests solely in the eye of the beholder is mere opinion. So there you go, folks. In Texas, calling someone explicitly a sexual predator is not defamatory. Not defamatory if it's a public figure and a matter of public concern, which if it's a public figure, you're talking about their sexual predation, that's a matter of public concern. Cheers, chat. All right. Noting another court's explanation that unlike convicted felon, which has an objective verifiable meaning, sex predator is a sort of loose, figurative, or hyperbolic language that is immunized from defamation claims. So there you go. I mean, to me, that sounds like serious sexual misconduct, but I don't know. I'm not an appeals court judge. Furthermore, for a public figure plaintiff, an essential element of the defamation claim is that the defendant published the alleged falsehood with actual malice. The status of the person allegedly defamed determines the requisite degree of fault. In this context, actual malice means knowledge of or reckless disregard for the falsity of a statement, i.e. proof the defendant's state of mind at the time of the publication. Noting that the constitutional focus on the defendant's attitude toward the truth, not his attitude toward the plaintiff. The mere failure to investigate the facts by itself is no evidence of actual malice. Likewise, the mere fact that a defamation defendant knows that a public figure has denied harmful allegations or offered an alternative explanation of events is not evidence that the defendant doubted the allegations. Proof of reckless disregard requires evidence that the defendant had serious doubts about the publication's truth. For a TCPA non-movement to make a prima facie showing of the elements of defamation, the party's pleadings and evidence must establish the facts of when, where, and what was said, the defamatory nature of the statements, and how they damage the plaintiff. This is because in defamation claims, context matters. Saying that without providing the context of the allegedly defamatory statements that plaintiff was abusive, there's no basis for the trial court to conclude that the statements were defamatory per se. In construing a statement to determine whether it was defamatory, we view it as a whole in light of surrounding circumstances based on how a person of ordinary intelligence would perceive it. So we're going to come up to here is the idea that providing all of the tweets that said stuff about Vic Mignogna is completely invalid unless you provide all of the context surrounding those tweets. Which means the preceding Twitter thread for all of them. So that was not done in this case. That was not done in this case. And that's what that says. No evidence of actual malice as to Markey, Rial, or Funimation. Mignogna argues that Markey defamed him through her statement that he had assaulted her by grabbing her hair, yanking her head back, and whispering something sexual in her ear. And this is where we will find significant fault right on the shoulders of Vic Mignogna himself. We're going to find that from his deposition. How the deposition reads is a problem. How Vic answered the question is a big problem. It's unfortunate, but it's true. Now, if you watch the depositions in order, I initially played them slightly out of order. on this particular spot. There's a break between the two files, and so it was kind of backwards. But if you watch them in order, you will note how the answer is initially made and then it is clarified. The answer should have just been no. That should have been no. Did you pull her hair? No. Instead, the answer was explained. Well, I didn't really pull it. I more like touched it, blah, 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 blah. It wasn't hurtful, et cetera, et cetera. Nope. The answer is no. And this is why answers in depositions, answers on the stand are so fucking critically important. So here we go. Mignogna argues, in his first amended petition, he alleged that on February 8th, 2019, Markey tweeted that he had assaulted her several years prior by grabbing her hair and whispering in her ear what he whispered she couldn't remember, that in the last week or so, I've heard accounts of him doing this exact things to a dozen other women that I personally know, and that Mignogna is a predator. This whole thing, half a dozen other women, this is that bolstering bullshit that happened in the same way that it happened with Johnny Depp. Like, oh, there's more stories about this. Sources, trust me, bro. Markey's entire tweet stated this. Here's the tweet. I'm not going to read it all because it's long. We've read it several times on the show. In her unsworn declaration, Markey stated that she decided to publicly state the truth about what Mignogna did to her, end quote, in early 2019 after other women began coming out with the truth about their various experiences. Right. So this is the pile on thing. She'd had no issues with this. She's friends with Vic for years and years and years. And suddenly this thing that happened years ago is a problem that no one knew was a problem. Whatever actually happened, that's the other question with him, and that she did it so that other women who were victims of Mignogna or other aggressors would know that they are not alone, and to show solidarity with and empathy for those victims. Markey further declared that she had told the truth and had since been harassed, threatened, and lambasted by Mignogna's supporters and his legal team, even though she had not made these statements out of malice or any desire to hurt him, despite her own hurt and anger. Markey stated, my intent in my outcry was always to provide an opportunity for healing and encouragement for bravery for both myself and other victims. In his deposition, Mignogna admitted to the incident involving Markey's hair, but stated that it was not painful, was not hurtful, it was not sexual, and it happened at least 4 or 5 years ago, maybe longer. There you go. Done. Killed his claim. Killed it. If you remember, while watching the deposition, I say, please just say no. And then he didn't. Just stop trying to explain stuff. The answer is just no. He doesn't actually admit to the incident. What he tries to say is that she's completely mischaracterizing the interaction. But the way it comes out is, no, it wasn't painful or hurtful or not sexual. It gets worse too. He denied ever having whispered anything sexual in her ear, or having any sexual interest in her, which that makes sense. She's hideous. Mignogna testified that Markey had defamed him by publicly posting and mischaracterizing a very casual, brief interaction in public at the lobby at Funimation, and that to his recollection, it was a very casual, playful interaction as happens all the time in the hallways at Funimation. However, he agreed that Markey could have perceived the incident differently, which he also should not have done. Could she have taken it differently? No, that's ridiculous. And she didn't. How do you know? Because she didn't act in any way contrary to a playful interaction. She didn't take it differently. She's lying. She's a liar. She's a fucking liar. That's what you say. But that's not what was said. And that has to be dealt with. You're not in normal conversation with normal people in a deposition or in being examined or cross-examined on a witness stand. They're looking for the gotcha. You're in the most hostile environment ever. There is no explanation. There is simply no. Did you grab and pull her hair? No. That's crazy. You didn't grab her hair and pull her head back and whisper something sexual in her ear? No. My God, that's horrible. Because he didn't. Like, the answer is that he did not do what they said. Now, what he wanted to do was tell them what did happen. No, 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 no. Mamma mia, mamma mia, mamma mia. Shut your mouth. Don't tell them what did happen. They have to get the story out of you. That's their job. Your job is to say no. He did not recall if he said anything in her ear, but said, if I did, it was literally something about, ooh, I love your hair, or love it, it's awesome. Do you remember saying something in her ear? No. Like, no, just no. Just no. No is the answer. No, no, no. He also agreed that Markey was not the only woman whose hair he had pulled. Also not quite accurate to what he said, but it doesn't matter. And when asked if he had any evidence that Markey did not believe the statements to be true when she wrote them, he replied, I can't answer for her. I don't know what's in her mind. I can't say whether she believes it's true or whether she was joining in to pile on. I don't know. The answer to that question is, of course she knows it was false because it didn't happen. I didn't pull her hair. I didn't whisper in her ear. Therefore, when she says I did, she knows she's lying. There's no way to interpret things I didn't do as to something I did. Mignogna's TCP evidence did not show that Markey had published a false statement of fact, or that she did so with knowledge of or reckless disregard for the statement's truth or falsity. Accordingly, the trial court did not err by granting Markey's motion on this claim. We overrule this portion on Mignogna's first point. There you go. Unfortunately for him, that one's on him. That's his statements at the deposition that did him in. In his first amended petition, Mignogna alleged that Rial had made the following statements or had taken the following actions to defame him. She liked and retweeted a tweet by Han Leia, liked and retweeted 2 tweets by Mars Girl. She tweeted, it happened to me. He's hurt people. He's a sick man. He needs help. Multiple investigations, etc., etc., etc. She accused Mignogna of sexual harassment, of kissing her without her consent, and of treating others similarly at conventions. Let's see. Here we go. Mignogna argues that he specifically denied Rial's accusations against him, but to support his assertion, he primarily references his affidavit and Slaytosh's affidavit, both of which he withdrew before the TCPA hearing, and his unsworn declaration, Slaytosh's unsworn declaration, neither of which the trial court considered because they were attached to a second amended petition. So there you go. His evidence is not included. Further, despite having attached Rial's entire deposition to his TCPA response, Mignogna provided no evidence of her state of mind with regard to the actual malice element. Okay, so here's the thing. In Texas, the actual malice element is tough to fulfill everywhere, but here's how you fulfill it. We were the only 2 people present. What she says happened is not true. She knows it's not true because she's there and claiming something happened to her that never happened. So she knows it's not true. There, you fulfilled it. There's actual case law. I don't remember the case off the top of my head, supporting the idea that what occurs between 2 people is known between those 2 people, and a contrary story means that they know that they're telling a lie. To the contrary, as to at least one of the complained of statements, Rial testified in her deposition that her February 11th, 2019 tweet, which stated, "And just so we're clear, he's the legal definition of harassment. Harassment is governed by state laws, but is generally defined as a course of conduct which annoys, threatens, intimidates, alarms, or puts a person in fear of their safety," contained a typo. Rial testified that she had intended to say, "Here's the legal definition of harassment." She stated that she had copied and pasted the definition of harassment she found on the internet into the post. Mignogna provided no evidence to refute this characterization of her statement. He literally couldn't, because her deposition occurred after his. So she was allowed to state that, then there wasn't really a response that he could make about it. And likewise failed to meet his burden to show a prima facie case of each element of defamation, particularly falsity and actual malice, as to Rial and his TCPA response. Accordingly, trial court did not err by granting the motion on the claim. Mignogna argues that Funimation defamed him by publishing two statements about him that, when viewed together, conveyed a false and defamatory meaning. In his first amended petition, he alleged that they had defamed him when they published the following tweets. "Everyone, we wanted to give you an update on Vic Mignogna's situation. Following an investigation, Funimation recast Vic Mignogna in Morose Mononoke in Season 2. Funimation will not be engaging Mignogna in future productions, and we do not condone any kind of harassment or threatening behavior being directed at anyone. As with the other defendants, Mignogna produced no evidence to meet the actual malice standard. Accordingly, the trial court did not err by granting Funimation's TCPA motion. We overrule this portion of the first point." Again, all of this is in Vic's affidavit, unsworn declaration, is where he would have pointed to for that, but didn't get in. No evidence of the context of Toye's tweets or actual malice. His first amended petition, again, no second amended petition, which, in my opinion, is a more thorough document that deals with some of these issues. Mignogna alleged that Toye made the following statements or took the following actions. Mignogna is a predator. He knew of at least 4 assaults by Mignogna. Glad to see conventions canceled. That kind of looks like defamation, pretty specific there. Defamatory per se. Toye tweeted that he knew Mignogna was guilty of at least 4 accounts. Defamatory per se, because that's accounts of assault. But all of these tweets that they have here, they don't have the context of them. Mignogna also alleged that Toye had tweeted more than 80 times that Mignogna had sexually assaulted or assaulted Rial, more than 10 times that he had sexually assaulted or assaulted 3 of Toye's very close friends, more than 10 times that he had been accused of hundreds and possibly thousands of assaults, and at least 17 times that Mignogna is a predator. Mignogna's pleadings and evidence had to establish the facts of when, where, and what was said. They did. I mean, they include all of those tweets, the defamatory nature of the statements, pretty obvious, and how they damaged him. However, Mignogna merely attached 342 purported tweets by Toye without their surrounding context. The tweets to which Toye was responding, which is required to determine if a statement is defamatory per se, according to Bill Bray. Further, the tweets referring to Mignogna as a sexual predator or variations whereof are non-actionable opinion. And as with Marky, Rial, and Funimation, Mignogna has also failed to show that Toye acted with actual malice. Because Mignogna failed to meet his burden to show a prima facie case of defamation as to Toye, trial court did not err by granting his motion on the claim. We overrule the remainder of Mignogna's first point. So there you go. There you go. None of Ron's defamation mattered because there was no preceding tweet attached, even though the defamatory nature and meaning of the tweets seemed obvious to pretty much anyone reading them. Court says no. Mailman says, "Can I get a good word for my girlfriend's best doggo, Marley, who recently and unexpectedly developed severe health problems? Marley saved her life when she was younger and has been a blessing since. Thanks, Rackets. And cheers." To Marley, a friend, a companion, a pet, and in some ways a confidant. To a pet who not only just like loafed around and was fun to hang out with or ruffle ears or whatever you do with pets. I mean, I don't even know. Pets are disgusting and degenerate to me. But this has truly become a friend, and a friend who provided life-saving care at one point. To Marley's swift recovery, may it be complete, and may their companionship last long into the future. Cheers to Marley. The Meep Kid says, I got a question I've been wondering. I try to look it up. I can never find. Can I sue a law for being unjust or unconstitutional? No, you cannot sue a law. You have to sue an official over the application of said law. All right. What do we got? Oh, shit. Engine Idiot over on Odyssey. Since a whole bunch of conductor we have a problems. Thank you for that. And then Chank Sautom says Vic's biggest problem was always his naivety and softness. In a lot of ways, I agree with that. He believed these people were his friends, and this was all misunderstanding, and he could clear it up by just explaining things. Vic was soft and weak. Hopefully, this hard lesson is shown in the truth. The world is a cold and harsh place. It's really tough, man. It's really tough. He's in a rough spot. I'm guessing I'll probably talk to him tomorrow, but I'm not super looking forward to it. I think this is a big blow. So let's see, what do we got next? Here we go. Claim for tortious interference with an existing contract. Plaintiff must show the plaintiff had a valid contract with a third party. The defendant willfully and intentionally interfered with the contract. Defendant's interference with the contract proximately caused plaintiff's alleged injury, and the plaintiff incurred actual damages or loss. Elements of tortious interference with business relations is similar. I'm not going to go through them all. Mignogna testified that he averaged attending between 20 and 30 conventions a year, and by the time of his June 26, 2019 deposition, he had attended 9. He further testified that it was not unusual to not be invited. See, this testimony is going to end up harming him. Not unusual to not be invited to a convention he had attended the year before, quote, because once the convention has you as a guest, they don't typically bring the same people back every year because of the number of people in the industry. This is the wrong testimony to give. Mignogna added, and when I say this, by the way, some of this is hindsight. Vic is trying to explain how the industry works, and he's going to get burned by it. Because the implication is normally people don't get invited back, but I get invited back all the time because my milkshake brings all the boys to the yard. Like, that's what he means, but it gets pulled here in this specific way to say that, well, he probably wasn't going to go back anyway. And I think the second amended petition did a better job, but what needed to happen at some point were questions to Vic about each one of his appearances and why he believes he had a contract. They had asked me to appear. I agreed to appear. We had agreed on a minimum. My minimum is $5,000 or whatever it is for an appearance. They had said they would pay for my plane tickets, and they said that once we start advertising your presence, then you're going to be in. They advertised my presence, and then people complained to them, and then I was removed. Therefore, I had a valid contract. It's these people's fault that I didn't have the contract. That should have probably been fleshed out somewhere. I can't remember if the second amended petition does it. I know it was better than the preceding petitions, because I believe it frankly lays out that once something is announced, that there is actually just an oral contract that exists at that point. But here we go. Mignogna added, in fact, I'm actually an exception because I do get invited back often in the same event. So if somebody doesn't invite me back, there's nothing really unusual about that. It's a problem. He stated the number of conventions fluctuates from year to year. While some would involve written agreements, others were based on oral invitations. Mignogna agreed that he did not go back to MetroCon Tampa in 2018, was not invited back in 2019, and that he had not been back to Anime Central since 2016 or 2017, and that although he was at TokoshoCon in 2018, he was not invited back in 2019. These are all fine things and have literally nothing to do with the specific anime conventions that he listed in his complaint that he was invited to, and then disinvited from specifically. Like, that's just left out of this opinion here, which bothers the shit out of me. John T in the chat with the all wise says, why was the first petition so bad from your family lawyer? My family lawyer is, again, he's a lawyer who has done work for my family. Yes, that is true. Why was the first petition so bad? I don't know. You'd have to ask him. And the second one done so late by your family lawyer as to not be admissible. First of all, I think it should be admissible. I think the law is on the side of admissibility here. And I think absent the Rule 11 agreement, it would be admissible. And I think with the Rule 11 agreement, it should still be admissible. But that being said, I don't know. Ask him. Or don't. Or you can shove your own dick in your ass like you do every Tuesday. Right? You fucking piece of shit. Is that what you want me to do? You want me to respond to you? Are you so desperate for a response? I don't know how to tell you this. I'm not the lawyer on the case. Wasn't the lawyer on the case. If you want answers about it, go ask him. If you can manage to get some other guy's cock out of your mouth for 10 seconds to do it, try it. I don't know. I'd love to know these answers, by the way. I would have preferred that everything just happened nicely because I think Vic had a good case. But you're barking up the wrong pole, man. I know you're used to barking up poles, but this is not one that's friendly to you. Pepsi Man says, why is Ty Beard given so much leeway? You have no problem criticizing Vic's deposition. I did criticize Ty Beard. I said the biggest mistake in the case is the non-inclusion of the affidavits in the second amended petition. Huge problem. The notarization, huge problem. The number one issue in the case, second amended petition not being included, which may have saved it, may not, don't know, but I think it's the biggest thing. But Vic's words are also a huge problem on all of this stuff because Vic's deposition was included as evidence in not only his filing, but in all the other filings. So had his deposition been more complete, maybe, which, by the way, you can blame Ty for that too, probably. And you never can perfectly predict how a client will perform on examination or cross-examination. But I guess you can always blame the attorney and say that he wasn't adequately prepared or the right questions weren't asked. I don't know what to tell you. Not going soft on Ty here. Not going soft on Vic either. I do disagree on the Rule 11 thing. I think that's an incorrect ruling by the court, but my opinion on it doesn't fucking matter. So here you go. Let's see. Mignogna agreed that he did not go back. Oh, wait, read that one. Let's see. Mignogna then repeated, as I said, typically with 70 or 80 voice actors and industry people, writers, directors, artists, they don't typically invite the same people back every year. Again, the court, the reason I'm bringing up Vic's deposition is because the court is quoting it. Like, they're telling you what the problem is with this stuff. They said the problem with the affidavits before, the notary and the withdrawal of the affidavits, and then the subsequent late filing of the second amended petition. At this point in the case, what are they talking about? They're talking about Vic's deposition right here. His deposition's got some problems. Mignogna admitted in his deposition that with the exception of one convention, Kamea-Con, he had no written evidence, emails, text messages, or anything to show that appellees had contacted or encouraged conventions not to invite him. Further, Mignogna was able to attend Kamea-Con Although he testified in his deposition that prior to 2019, to his knowledge, he had not been banned from a convention or asked not to come back. See, and this is, let's see what they say in this thing. As pointed out by Real and Toy in their appellate brief with regard to Kamehacon, Mignogna admitted that he actually attended this convention under a superseding contract that he did not enter into evidence. Mignogna's entire claim for tortious interference is based on a single convention that he was not barred from attending. Now, the superseding convention is in evidence, or would have been in evidence, in the testimony of Chris Slatosh, the affidavit of Chris Slatosh, but that was withdrawn and then not regarded for the unsworn declaration that was attached to the second amended petition, which is where that whole fiasco was talked about more specifically. I don't know if there was a written contract for the superseding contract. Again, Texas honors oral contracts, so you don't actually have to have anything written down, but this is all discussed in open court, which apparently is not evidence. In his deposition, Mignogna acknowledged that he did not know of any instances when Funimation pressured a convention not to hire him or to allow him to attend, and he failed to link any specific Funimation statements to any lost business. Appellee's evidence also showed that there was substantial negative press. This is a hard one. This is tough because the conventions that are pressured not to allow him to attend aren't going to say Funimation did it, because the reason the pressure works is Funimation says we won't let our voice actors attend if you do this. And so then if they say, oh, well, Funimation told me they wouldn't let their voice actors attend, guess what? You're not getting the voice actors. Like, that's just how that goes. Appellee's evidence also showed there was substantial negative press arising from claims of other individuals made before about the same time and after Appellee's made the statements Mignogna complained about, and Mignogna failed to show that any convention's decision not to invite him stemmed from Appellee's statements rather than from routine decisions or as a response to negative press. Of course, this is stuff that you would normally want to address at trial, because you would ask questions about why. You would bring people in and ask them questions about why they didn't attend or what the negative press was that they heard and all that stuff. And you would presume, you would bring in witnesses that say that they saw the rumbling on Twitter, specifically from Monica Rial, Jamie Markey, from the Funimation firing letter, and that they had seen stuff in the past, but they had ignored it. That's what you would want on the witness stand. Like, because we've already got earlier in the case this idea that, Vic had a rumor panel back in 2010 to address this stuff. So the court already knows that this is out there, that this has been out there, and the jury trick that you have to do. Now, you have to get past the CPA to do this, but the jury trick to do, similar to the Johnny Depp case, is to show the jury how the current statements are the ones that changed the tide from all of the previous statements that had existed. The previous stuff had already been said about Vic, but he's still getting convention invites. Suddenly, this thing happens, and now he's disinvited from conventions that he's invited to. All of those previous negative press things clearly didn't impact his career, but you have to show that to a jury. At the prima facie stage, here at this early stage, you have to present evidence just that he was going to attend a convention, this stuff happened, and then he was removed from the convention. That's it. Because they don't get the opportunity to controvert these assertions. The court's claiming that wasn't sufficiently done. And I think the first amended petition was a failure on that front. The second amended petition more clearly laid out specific statements attached to the cancellation times for these things. It also, if I remember, more clearly lays out specifically the idea of the oral contract and how convention appearances work. Personally, again, I'm not anybody's lawyer here, but if I were, all convention appearances going forward would include written contracts, every single one of them. They would all have written contracts with signatures, wet ink. Mail me a physical copy. I want it. Shit. But that's me. I don't know. I have no idea, by the way. I know, again, everyone thinks I'm Vic's lawyer and that I have something to do with all of this stuff. I have not only never represented myself as Vic's lawyer, I have always specifically referenced myself as not Vic's lawyer and having nothing to do with this. All right. On the record before us, Mignogna failed to present any evidence that he had a valid contract or would have had a valid contract, but for interference by Marky Rial. When asked by the trial court at the hearing on the TCPA motions who Marky had contacted, Mignogna's counsel replied, she does not, as far as we can tell. Which, again, this is one of those quotes which looks bad. I know people are going to, oh, you're guarding Ty here. I'm not. I'm guarding lawyers in general. See what else it says. When asked by the trial court about the tortious interference with prospective business claims as to Marchi, Mignogna's counsel replied, same answer. You say, Your Honor, her initial tweets, this is a criticism of Ty, by the way, but mitigated by the fact that if you were in the courtroom that day, everything was a fucking disaster. But what the ideal answer would be, Your Honor, she's a voice actor who's prominent in the industry, tweeting about this stuff at a specific level. Whether or not she specifically contacted these conventions, we'll have to find out on discovery. But we know that her tweets correspond with the I'm fucking this up because it's on the fly. This is actually really tough to do. But her tweets as an industry professional with direct contact and knowledge of the plaintiff are things that would be seen by conventions that the plaintiff was attending. And we know that these conventions following these tweets removed him from this stuff. And we know she knew about these convention appearances because these convention appearances were published the moment the conventions announced Vic Mignogna, and he was removed afterwards. So you go with that. And then on discovery, you try and find out if you can find anybody she specifically contacted. But the tortious interference claims against Jamie Markey were particularly weak. They were much stronger against Monica Rial and Ronald Toye because of the specific discussion they had between Kamea Khan's Chris Slatosh and Ron Toye and the text messages that they had, which were attached to the unsworn declaration, which was not entered into evidence because it was attached to the second amended petition and not considered because of the Rule 11 agreement. Rule 11 agreement decision by this court really fucked them on that second amended petition. There's no way around that. Like, that is, again, I think the critical issue. And I'm pretty sure that that's what I said at the start. If they can get the second amended petition into this case, that's their main hope. If they can't get it, they're going to have a really tough time winning on anything else. Here we go. Toye or Funimation that any such interference approximately caused them actual damage or loss. I mean, they actually do have this. Again, it's in the Slatosh stuff. Or that he was not invited to a convention because of something any of them did. Again, in the Slatosh stuff. Accordingly, trial court did not err by granting Appellee's motion on these claims. We overrule Mignogna's second and third points. Civil conspiracy. You're not going to have civil conspiracy if you don't have the underlying claims. So I'm going to skip that section. Attorney's fees and sanctions, TCPA. And I'm not going to read this whole thing because I'm getting tired of it, but I'll summarize this because I did read it before the show. TCPA, in effect, at the time of the litigation, required the trial court to award to the successful movement reasonable attorney's fees and sanctions, among other items. Mignogna challenges the imposition of attorney's fees and sanctions, while Rial and Toye challenged the amount of their attorney fee award. Okay, let's just do it this way. Vic says they got too much. Monica and Toye say they didn't get enough. All right. Trial court says the judge is free to award within his discretion basically anything he wants on the issue. However, the opinion rendered does not provide a sufficient basis for the judge's determinations that he made. Therefore, we are sending this back for a rehearing, or I shouldn't say rehearing, might be a rehearing, but a remand and retrying on the issue of fees specifically. The likely outcome of this is that the fees would be higher based on the lodestar calculations put forth by J. Sean Lemoyne. Now, what this may mean, though, is that each party has a chance to resubmit evidence about the fees. And in that case, Vic could submit evidence that they did extraneous work, too much stuff, and that the fees were reasonable at the point. What Judge Chupp will do in response to this doesn't really, like, there's no way to predict what he'd do. Maybe he'd say, I'm going to award the exact same fees and just provide more basis for his reasonable award of fees. Or he could say, fuck it, I'm going to give them everything and award them a whole bunch more money. We don't know how this will turn out, but that's the determination of the court, that it is going back to the lower court for a rehearing. I keep saying rehearing, for remand on the fees. At the end of the day, of course, judgments are judgments. And what Vic ultimately pays will be up to what they're able to extract from him under Texas law. You can't take a house, you can't take a primary vehicle, and you can't take a certain amount of property. You have to go after extra property, various cash that someone may have. Typically, you would go after wages. You would garner wages, like someone works a 9-to-5 job, they get a paycheck. They say they make this much money. There's the wage. Then there's an additional amount of discretionary money that is allowed to the person. And then people are free to go after the extra amount. But Vic is a small business owner. His small business is him, his convention appearances. He is paid individually as an independent contractor. How his payment comes in, I don't know. Like when we learned in the Johnny Depp case, is that Johnny Depp himself does not get paid for his roles. In fact, he has a management company, and the company lends Johnny Depp's time in exchange. They basically rent out Johnny Depp's time in exchange for money. And so that money would go into a corporation. That corporation would pay out Johnny Depp various things that he needs throughout the year, stuff like that. I don't know how Vic's income is structured. I don't know how his assets are structured. All of that are completely separate questions. I don't know that we'll ever get the answers to those questions, but I will say this. In Texas, it is very hard to extract money from a debtor. It becomes much harder when that debtor is self-employed. How much he wants to fight it is up to him. In theory, what they could do is they could send someone to try and sit at a convention that Vic is attending and tabulate up all of his personal income that he receives as he sells autographs and pictures and such like that. And then try and extract some money out of that in court. That would be tough to do. That would be very tough to do. But I'm not his lawyer. I'm not his accountant. I'm not involved in how he structures any of that. So we'll see at the end of the day. I would assume if I were Vic's attorney and Vic were willing to fight, I wouldn't give them a red fucking cent. In fact, every single year I would send them a note that says, I owe you, and then it just says, fuck you, you fucking bitch, to every single one of them. Like that's what I would send them as the payment for the invoice or whatever every single year. And they could try and enforce it, but try and prove I made what you think I made is a lot different. That's a lot tougher. But that, I don't know what he'll want to do. I don't know how long he'll want to fight. I don't know how much they'll want to fight for it. Well, that remains to be seen, of course. With that, though, that's the gist of the decision. Again, very, very bad decision for Vic. Very, very bad decision for Ty. And I don't speak for Ty Beard. I know people want me to, and they say like I'm not criticizing or whatever. What I would suggest is that probably Ty Beard would take basically the responsibility for all of this. And I don't even know if that's a fair thing for him to do, because remembering there were 6 lawyers on this case that were not Ty Beard, but he was the lead attorney on it. He's the owner of the firm. And I think that, what he typically does in situations like this would be to take responsibility. But I don't speak for Ty. And if you want to know what he would do, you'd have to ask him. Maybe I'll have him on sometime soon. I don't know. That would be up to him. If he wants to sit here and have people shit on him the whole time, maybe he does. I don't know. But I can't answer for his actions or any other actions of any employees in his firm. Here's one thing I know about Ty, though. I'll say this. I've said this before, so this is consistent with it. No matter whose fault in the chain any particular thing is, Ty will accept the fault as his, whether he's responsible for it or not, because as the lead attorney, that's his job. And what you won't hear from Ty, I assume, is him throwing anybody else under the bus at all, even if it's possible that someone else might deserve it. But this is the way law goes, man. And it fucking sucks. Ty's in the chat. He says it's my fault. Well, there you go. There you go. Let Ty in. Well, I don't know if Ty wants to come on the show. If he does, I suppose he could. Oh. Let's see. We'll see. Check your text, Ty. In the meanwhile, let me read some more of these super chats. Valiant Renegade says, "Hail to Nick. The mods don't hail the mods." And the chat just wrapped a stream with good logic, and we rated yours. Thank you for all your hard work and intellectual contributions to societal discourse. Invitation on your DMs. Sipping some Four Roses single barrel. This man's trying to kill my sleep schedule. Ty says he'll come on. Let me send it to him. Hold on. I gotta find my fucking email window. Typical Rick shifting the blame. You're right. It's actually my fault. It's actually my fault. All right, here we go. Da, 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 da. All right. I mean, I only have to be up at I have to be up at 10 a.m., which doesn't sound early until you realize that I'll be asleep by like 6. Spartan of Light says, I just want to say, conductor, we have an FU cringe problem. This injustice will not stand. Oh, and also real sad about Vic and all. I am too, man. I hate it. Thanks, I hate it. Malachi Gaming and Talk says, will Ty retire per his promise to Vic's mom? I don't know. Did he make that promise to Vic's mom? Joe Ball, after this appeal, let's all have some peace of mind and back my comic Death, Death, Death. So close to 60,000 on Indiegogo. So close, chat. 300 pages of action, excitement like you've never seen before. Joe Ball, while you're here, I don't know if you heard, but while I was in the Caribbean, I ate an entire chocolate bar full of mushrooms. They said to eat one, and I ate 3, like it's 3 segments. And after that, I have a whole manga series that could be done, but requires the talents of an artist of your caliber. Because I think it'd be really fucking cool. And I think it's right up your alley. So Joe, yeah, I know you're like going to work on Yellow Flash's book or something really hyper homosexual, but I have a good one. Why? Because I was on vacation to do fun shit. And I stayed in my bedroom because that was the right thing to do. It was wild. It was an interesting time. RN Rules says chat should check out Scott Cardinal. He and Law and Lumber are doing Crimes of the Century. The elf from Canada stops in on occasion. Very interesting stories. Matthew Brazel, please shout out FOG Smoke Pit channel for watching your stream together, especially Setsuna F. Sei for hosting it. What's up to FOG Smoke Pit? I'm going to sue you for watching my channel together, like in one spot, because there's probably like at least 3 of you, and every one of those views is like 8 cents or whatever. And so, wait, yeah, I gave Ty the invite. Okay. Like I really want my 8 pennies from you. And okay. Cody Byers says, let's be real. We knew this was how it was going to end at this point. Balls were dropped. People are going to be annoying on Twitter, but Vic is still working. Now we got a good dubbing studio. I'll take it. And with that, I'm going to bring Ty on the show. Welcome, Mr. Ty Beard.
Howdy.
Well, I'd ask how do, but I think I know the answer.
Yeah, well, I didn't get much sleep tonight, so I was watching your show. Thought it was a very fair analysis, and yeah, it's my fault. Of course, it is. I was the leader of the team. I made all the strategic decisions. My people did a good job. You know, basic principle of leadership: the leader takes the blame. That's the way it has to be for leadership to work. But yeah, I thought actually your analysis was pretty spot on. I don't have a lot of answers to some of those questions. I've got to meet with the team tomorrow and break this down further. But you know, the public figure part is tough, and I do think the Court of Appeals muffed that because the opinions out there make it very clear that to be a public figure, you've got to be broadly popular in the entire community. You know.
Right.
And so I'm sure we'll file a motion to reconsider. That's where you ask the court to you say, look, we think you did this wrong, that wrong, the other thing wrong, please reconsider. You know, what often happens when you do that is the court will say, you're right, but you still lose.
Yeah. I mean, that's the hard part about a motion to reconsider
Yeah.
I
Yeah.
mentioned that in response to the Rule 11 here, the Rule 11 ruling, which I personally think is I don't see how you're a contracts guy. Like
Yeah. I drafted
people.
the Rule 11. Do you think there's any coincidence that the petition is not in that?
So
I mean,
people don't know this because like there's a meme that you're just an estate attorney, but you're a commercial attorney as well. You
a
do all
business
sorts of
lawyer and do both
right.
litigation and transactions. Now that it's unusual to find attorneys that are that broad, but yeah, I mean,
But so
uh,
you deal with the contract law with relative frequency, and my issue with the court, my biggest issue with this court decision, which I mean, when you lose the second amended petition, I see their decision, right?
yeah,
I got it,
yeah.
and there I might nitpick here and there, but ultimately, I think the second amended petition
Well,
was the most important part of the case.
yeah, I agree. There's no gainsaying it. The notary foul up was that was pretty bad, and that was on me. You know. By the way, can you send me a link to the chat? I can't actually see the chat.
Oh yeah.
I don't know. Maybe I don't
Where do
want
you
to,
want? Do you want me
but
to send it? Do you want me to email it, or do you want me to send it on?
I guess email it. Yeah, that'd
Okay,
be.
hold on.
Well, hold on. So of course, Outlook has crashed.
I can send it to you on Messenger or whatever.
Just email.
Oh my god. This should work.
Yeah, I'm one of those folks that takes every loss very, very personally. You're not supposed to do that. They tell you, old veteran lawyers tell you, you can't do that. I do, always have, and I don't suppose I'll be changing anytime soon. And this one's tough because Vic didn't deserve this, and that's what do you want to say? I mean, of course, there are various people in there gloating, but as you very correctly pointed out, we never got our day in court. We never got to the evidence. And what evidence we do have, watch the damn depositions. What rational person actually believes the defendants? I mean, man, I don't know why, but all of a sudden, Outlook is blowing up. Hold on.
Everybody's emailing you at the exact same time.
Yeah, probably so. Probably so. Let me see here.
I'm going to do this thing where I send you a message on Facebook, and
yeah, you can do that. You
can just click on it on your computer, and it will give you like this magical thing will happen where the window just pops up for you.
Well, you say that. Let's see if that can. Oh, are we live, by the way?
We're live. Yeah, we're very live.
Sorry. I was just, let's see here. Yeah. Okay, there it is. Let's see. I got to duck down under my. There we go. There's the chat. All right. Now I can function.
I mean, I guess that's how you do
it. Yeah. By the way, I, after COVID, of course, a good chunk of my every day now is spent on Zoom. And so I've always got the best camera and microphone of everybody on Zoom. So thank you for that.
You're welcome. Even though it's potato cam in reference to my magnificence.
Well, of course. Sure. I mean, I'm 3 years behind you. That's a lot of forehead, Ty. Yeah.
People don't realize with with lawyers on like Zoom and stuff, which your average thing is a laptop from 2009 and its camera and microphone, and they're just yelling at the screen because they don't even have headphones in. It's crazy.
Oh yeah. That's another thing. Zoom, no headphones. Although Zoom works okay for business meetings, but yeah, there's a lot. It's a lot like a seance. You're trying. Are you there? Can you hear me? Are you muted?
Yeah.
So
Well, what do you? I mean, I don't know what there is for you to say about the case or the appeal, but what would you want to say? I mean,
the main thing I want to say is confirm your prediction that I would take responsibility. Absolutely. It's my fault. That's just, it would be very, I'm not the kind of guy that's going to shirk responsibility. Never have been. You know, how do you look at your children? You know, if you blame somebody else or throw other people under the bus. And sure, you can always find failures in the chain, but the reality is you pick those people, you know, and you supervise them, and so it's at the end of the day still your responsibility. But you know, we're definitely. I think it's almost certain we're going to file a motion to reconsider. We got 15 days from the time of the opinion. We're going to certainly ask for extra time because this thing drops right in the middle. I've got another trial actually Monday after next. So
Sure.
you know, we will. I would anticipate the court will grant that. The odds are not great for us because our arguments. One of the problems with our arguments are if they grant our arguments, they're going to have to do a whole lot more work.
Yep.
Because by a priori excluding the our evidence, basically, you know, if they say, oh, you know, you're right, we shouldn't have done that. Well, now,
Then they have to redo the
yeah,
analysis
and
at
so
that point.
you know, I mean, they should, in my opinion, but I think it's problematic. I saw in the chat some people were talking about the Supreme Court, Texas Supreme Court. Um, the Texas Supreme Court takes a very tiny percentage of cases that are appealed to it. So our decision there is going to be more a function of economics, you know, because the legal fees continue to mount. And so I wouldn't read anything into whatever decision we come up with. Some folks in there asked if I talked to Vic. Yes, of course I called him immediately, and you know, he he wasn't happy. I don't think anybody would expect that, but he'll be fine. He's you know he's a tough guy, and he's been through a lot. I just you
Yeah, I
know
think it's
we
pretty
just came up
fair.
short.
I think it's pretty fair to say he's a complete. I shouldn't say completely. He's a very different person than he was in 2019 when this was happening. I mean, he's been tempered by this campaign against him in many ways,
Yeah.
and I think in a lot of ways he's probably stronger.
Oh well, I don't think you could go through this and still be alive without being stronger. But you know, um, somebody in the chat compared me to Eddard Stark. Maybe
But
I'll always take a comparison to Sean Bean.
yeah, but just remember his head ended up on a spike.
Yeah, yeah, yeah. No, I couple of things, and this isn't in the nature of you know me trying to defend myself or anything. Just clarification. Um, I was not particularly nice to those folks. There were certain things that you know you do, as you know, you do because you think it's a better strategic play to make. I felt like this judge was not a big fan of you know what I call lawyer bullshit, and he gave every indication of that. So you know I went with that. Uh, yeah, the hearing was just surreal. And what you have to remember is when you got a hostile judge that's just you know pounding you, you know you can go along with it to some degree to try to calm him down so that you can reason with him, or you can just get in his face. Well, I tried both.
Yeah.
And unfortunately,
Well,
getting in his face worked better, but I didn't find that out until you know
yeah,
that's generally considered a very risky strategy.
I didn't talk about it on this stream, but I do remember talking about it in the past. That hearing was such a weird, like again, um, judges act in semi-predictable ways. That hearing came out of left field in a lot of them,
Yeah.
and the first half of the hearing was completely different from the second half, and there was a distinct shift in strategy. At first, you were kind of conciliatory. Unfortunately, as it happens, a lot of that sort of conciliatory stuff revolved around some of the issues that I think became the most important, the admission of the second amended petition and stuff like that. So like the way the appeals court characterized some of the statements that were made in court are in the context of that conciliatory nature. What ended up happening in the second half of the hearing was different, and there really isn't any quotations from it, but that's kind of because you were actually communicating with Judge Chupp at that point a little bit
Well,
more
I'd
effectively.
gotten to the point where I decided I didn't care if I got tasered
Right.
because being conciliatory had failed miserably. We uh, Ann Lee asked for a 5-minute break. I don't know if you remember. And we walked out, and and I'm just sitting there, and he says, "Calm down, catch your thoughts. This isn't working." I said, "Yeah, no shit."
Yeah.
And that was a heads up play by him. Look, my team, they're good lawyers. They're very good lawyers. So it's kind of a one-way ratchet. Had we won, I would have given them the lion's share of the credit because they did do such a good job. But at the end of the day, it's my fault. the, I have rarely in fact, I can't really ever think of any time where I said, I don't want to practice law anymore. And I'm not saying that now, although I've probably drifted closer to that tonight. Because the really, to anybody that's going to go to law school, one of the things that you have to understand is if you fail, whether you screwed up, the court got it wrong, whatever, doesn't really matter, or even your client blew it, doesn't really matter. If you fail, your client suffers.
Yep.
And I have a hard time reconciling that because I would take that bullet in a heartbeat, but you can't. John T. Ty is backpedaling. Oh, I guess he got I think he got the dick out of his mouth.
No, it's still there.
Hey, John T. You should probably think about how absolutely pathetic and useless you are that you actually care about this. I would be mad at you, but I feel sorry for you, you sad, pathetic piece of shit. So see, I'm not completely beat down. Biting off more than I can chew. No, we had all the firepower we needed. Look, in trials, mistakes will be made by both sides. I mean that, and there were on both sides. That's, that kind of evens out. Usually,
right.
We just now, I got to admit, the idea that 270 or 300 defamatory tweets somehow need context is just, I almost fell out of my chair when I read that. So we're going to obviously attack that in our motion.
Yeah, because some of them have an obvious facial defamatory meaning.
Yeah,
like when it says says Vic Mignogna assaulted 4 women, for example, like that's doesn't seem to require contextual, like I'm not sure what context would grant to that personally. That seems to be a per se defamatory statement according to the court's own definition that it cites in the opinion.
Yeah,
but
that caught me by surprise. The characterization of him as a public figure, though, and this is, I'm not trying to get myself off the hook. I'm just making a clinical assessment here. If he's a public figure, we would have lost that case regardless, because as you well know, it's damn near impossible to reach the verdict, especially at the stage we are in the TCPA, where you're not even allowed to collect evidence. And we're gonna point that out to the court too, that they're holding us to a standard that is impossible. You didn't produce evidence to prove this. Well, we couldn't. We were denied discovery. In fact, the only reason we got the depositions, I'll brag a little bit, was because I stormed into the court and asked for a hearing and said they're planning on deposing my client, then filing a TCPA, and that ain't right. And Chuck looked at opposing counsel and said, "Are you going to do that?" And the poor guy goes, "Well, no, of course not." And he goes, "Oh, okay. Well, in that case, I rule that everybody can be deposed before you file TCPA." So Chuck made some good rulings early on. I just the hearing just didn't go the way we wanted it. And Bronca's right. By definition, appeals are for losers.
Yeah. I mean, obviously, because if you win, you're not appealing.
Yeah, and but that statement doesn't get us very far, because I said this. Gosh, has it been 3 years, Nick?
It's 3 years. It's hard for me to I always think of it as 2, but it was actually 3 years ago.
Basically, the 2020 disappeared for everybody because of COVID. But I said this 3 years ago, the night I was down on the coast when we got Chuck's ruling, and I said, "Oh yeah, we're going to fight." That's what you do. You don't just go, "Well, we got beat, I guess it's over." I mean, at least that's not how I do it. And I don't think I'll ever change that about my personality. So I asked why it took so long now that it's out, well, if you want to know how long it took for the appeals opinion, that's easy. Uh, COVID
COVID COVID fucked
utterly,
everything up.
it really did. I mean, we've got trials that we would have had set in 2020 that we still can't get set.
Mhm.
So you're it's but yeah, COVID is the answer. It was a complicated case. Somebody asked in there too, what would you have done differently? Well, I'll be making that list over the next few days. Um, there were some screw ups that I would avoid. Uh, Probably miss. I should have had. I should have put Vic in the courtroom for that hearing. I had the obvious
If they would let
concerns.
you, if they would let you call him as a witness, that the
No, I
court.
think, well, yeah, even his presence though might have. I mean, because Vic's a very engaging person, and he puts a face on the damage. Um, I did it. I did it for reasons that are that were logical at the time, but in hindsight, I would do that different because I know I have a better feel for how he is in the courtroom. Um, we overplayed it. I mean, a little bit. You get bloodlust when you're drawing up these things. That particular mistake isn't really material because great. We should have played 14 instead of 17. What are you gonna do? So yeah, I always try to learn. I find that I've learned far more from my failures than I ever learned from my successes, and so yeah, this will be a learning experience. As far as what happens to Vic, well, yeah, I'll fight for the guy to the end of time at this point, um, and won't charge him a dime. So assuming he still wants me, um, you know, it'll get made right one way or another. That's a personal promise that I'll make. It'll get made right. Um, you know, but it's the notary issue, Ty. Yeah, no shit. Didn't we just? I think Nick said that 3 times. I've said it twice. Appreciate you saying it a sixth time, moron. Almighty. Understand, I'm not bitter because of the well, I am bitter because of the failure. But understand, I'm calling you an idiot because you're acting like an idiot. And you people gloating about this, let me clue you in on some things. Number one, Vic Mignogna is a far better person than either of the defendants. Okay, he is and always will be. Far more people like him than will ever like any of them. Uh, Opposing counsel can gloat all they want, but they won a technical victory. It never reached the merits. I never got to a jury. We never got to make our case. So you can't say, yay, we won on technical merits. See, he's guilty. That's bullshit. So gloat all you want to. I would consider how pathetic you are sitting here, yeah, you lost. Yeah, no shit. I've been doing this 27 years. It happens, you know. Um, but to other people, I would say this: this is how you act when you take a hit. You take responsibility for it. You try to figure out what you can do about it. You don't blame other people. You don't whine about it. I wasn't curled up in a fetal ball. I just couldn't sleep. I actually got to listening to your analysis and was kind of mentally taking notes for the conversation tomorrow. Yeah, it's a good point. And I thought, I can't sleep anyway. So,
Yeah.
do
Well,
you have
it's
any questions? I mean, that's
I mean, I don't really the stuff that I have questions about is really inside, it's stuff that I can't know. So I
yeah,
don't really
yeah.
want to get into that stuff. I don't want any appearance that I would know any of that stuff. The
How many times do you have to say I'm not his lawyer?
always
And by the
always one
way,
more.
I don't think I'm disclosing anything I shouldn't by saying this one thing. Nick made the introduction, then got off the phone call, and I spoke with Vic for 2 hours. So, the idea that you somehow, orchestrated all this, I mean, it just didn't go down that way. If you remember, I was going out to a client's location. Just the weird things that happened. The immigration folks had shown up at a manufacturing company's plant, And of course, they did exactly what they were supposed to and called me before they let them in. So I was heading out to deal with that. And so I took the call and then dealt with that and then called Vic back. So no, Vic, Vic hired me because he, thought I could do the job. He had a previous lawyer. I don't know if you remember that.
I
Um,
do. I remember.
I kind of liked her. I talked to her. You know, I don't know that her personality was really quite wired to handle this kind of a case, but and she admitted that. I mean, this is not disparage her in any way. I thought that the work she did initially was very good. I called and complimented her on that and asked her if she wanted to have any kind of continuing role because as you know, I'm the more the merrier is kind of my philosophy. So, but no, you didn't orchestrate anything. And no, I'm not. Well, I guess, in a sense, I am your family attorney to the extent that I represent a number of your family members on a variety of matters, but I'm not sure what that has to do with anything. Um, you know,
I don't know.
yeah.
It's like, who do you recommend for an attorney? Well, I could recommend someone who has done work for my family, or I could recommend someone who has done no work for anybody
Well,
I know at all.
you literally just made the introduction.
Yeah.
There was no, I mean, you need a lawyer in Texas. Well, he's in Texas and he's only an hour and a half away from you, um, you know, so,
I can't
yeah,
wait till I get sued. Like that will be the funny day for
no,
me.
yeah,
If
we ought to be
they
thinking
if they sue me for a negligent referral, I'm gonna have a blast. That'll be
negligent
great.
referral. That's an, well, again, I go back to the advice I gave that Duck Dynasty lawyer so many years ago. Don't bleep with this guy. Just don't, you know, um, yeah, somebody asked me where I was during Anime Matsuri. Man, I wanted to go to that so bad, but I'm working on a big business deal, and so of course it heated up. Right, and I was like, ah. So I want to, so yeah, I really did want to go and see all you guys, but
Next year.
yeah, yeah.
Someone said that this case is was it the biggest failure or biggest L of my entire life? Hold on. Let's see what do we got. This case is the biggest L of Nick's life, which I'll take it. Absolutely. That's great. If this is the biggest L of my entire life, I'm in a good spot.
I've never been this disappointed. I mean, is it the?
I mean, yeah, I'm
Yeah,
super disappointed, but
I'd have
like,
to.
but
Yeah,
I didn't do it.
yeah, right. It's not your fault, so it's kind of like,
I'll take
dude, that's too bad, but
I'll take the L for other people's issues all the
yeah,
time.
yeah.
If that's the worst thing
Um,
that ever happens to me, holy shit, I'm charmed.
well, you ask yourself these questions whenever you take it, and I don't take very many hits. I mean, I'm not bragging; it's just a statement of fact. And so, this one's. I can't remember a more disappointing hit than this, and
It sucks. It
it really
sucks.
does. And Vic didn't deserve this.
There's no way around it when you get an outcome for a client that is not what you're after. It sucks because you
Yeah.
develop relationships with these people. It's not just like
Well,
public defenders have a different sort of role, right? Like they get 300 cases. They deal with these people from time to time. And sure, there might be a case or two that stands out every now and then for them. But like private attorneys get hired by someone, you develop a relationship with them. They get to know you. They get to know your family. You get to know their family. You get to know their situation. You get to know what their hopes and dreams are. You get to know what their fears are. And then when shit comes crashing down, I mean, that's like having that happen to at worst, a cousin, but more
yeah,
likely something akin to a sibling or a kid.
it,
Like,
yeah, that's a good point. I mean, yeah, Vic's a friend. We've become very good friends. And how do you tell a very good friend I failed? That's tough.
yeah,
Uh, yeah, I will. Kind of did already, but I will again. But it's brutal. But I mean, this job is a serious job. It's not. You're dealing with people's lives. You're dealing with people's ask everything. I mean, it's not a game. Now, I tend to see it kind of as a game because I'm a gamer as a hobbyist, but it's not a game. I will definitely pass on the thoughts to Vic. Um, we'll We'll do whatever we can. I have to get my team together tomorrow, and of course, these appeals decisions dropping literally out of the blue. Uh, you know,
Yeah.
uh, it, we're not going to be able to talk until the early afternoon, but we'll have a game plan by tomorrow afternoon late. Um, but yeah, this is I would say this. I would ask everybody to pray for Vic. You know, um, got a
Yeah.
little extra. Pray that me and my team have wisdom because we're going to need it. Um, but like I said, you know, Vic's a great guy. He didn't deserve this. He didn't do it. You know,
Yeah,
and
that's the takeaway from all of this.
and
That's
all
so
you
frustrating.
and these pieces of shit in here that are gloating over that. It's like you proved nothing. I mean, I would genuinely be curious as to what you're actually gloating about, because I don't think you've even thought it through. Um, so
I'm just glad that in Texas I can call anybody a sexual predator, and that's not
just
defamatory.
remember
Well,
that
as
in
long as
Texas we have constitutional carry, though. So
it's got to be it's got to
you don't
be,
want to do that on Twitter. You're not going to want to do that face to face.
it's just got to be a public figure in a matter of public concern. You can be made a public
Well,
figure very quickly if the public concern is sexual harassment allegations. So like domestic abuse. So like I can say that Ron Toye III publicly acknowledged in court documents as a wife beater, that he's a wife beater. And I think that personally, my opinion, based on all sorts of shit I've seen about Ron Toye III, is that not only is he a wife beater, but he's probably a sexual predator as well. Like I'm relatively confident saying that because he tries to manipulate women by giving them gifts. He dated someone who he was the landlord of, which seems very, very suspect, giving laptops to women he barely knows. And also he sent me a bunch of sexual DMs. They seem sexual to me. So I think he's a
okay.
sexual predator.
Never thought I'd say this in public, but you.
Look, I'm just saying, I'm just here. I'm just a person on YouTube or whatever. And then I find out that this Ron Toye guy is like watching my YouTube videos and starts sending me creepy sexually charged messages.
Yeah, that's well,
Very, very much a sexual predator.
HM Toy gives a groomer vibe. That's an interesting statement.
Well, I don't want to keep you too long. I don't want to stay too long. It's already 2 a.m. I think what I'm going to do is finish up super chats, and then wrap up the show. Is there anything you wanted to say to anybody?
Really.
I mean,
Not really. I wanted to, I just kind of wanted to make it clear that this was not Vic's fault. I will say one more thing about depositions, by the way. I saw a lot of the chat saying, you should prepare your witness better. You do, but
look, what people need to understand something very critical about my critique of Vic's deposition. It's really easy to say that someone under cross-examination from an attorneys are interviewers who have a specific motivation that you don't necessarily know. It's really easy for me to say, he should have said this. He should have said that. This could have happened differently. That could have happened differently. Well, fucking yeah, of course it could in an ideal world. But the reason lawsuits happen is because no one is ever fully prepared for the ideal. You can do all the prep in the world, but the reality is simple. This is why police work. People want to tell their stories.
Yeah.
And they want to tell them the way they normally tell their stories.
You give all clients the same advice and you hammer them on this. You say, answer the question, just the question, and we actually war gamed. I mean, Ann Lee, we role played the deposition. Ann Lee did a great job in fact, he did a better job than Lemoyne did in the role playing to make, because a lot of times in depositions, it's the shock of hearing something that you're not expecting that unravels a witness. So anytime I've got somebody going into a deposition where it really matters, we actually will do a mock deposition. We'll I'll get one other lawyer to be the opposing counsel, and their job is to try to rattle the client. So we did all that, but Vic wanted to tell a story. And of course, one of the problems you run into is when a question is asked and your client starts answering it maybe a little too much, you're not allowed to object. You can't you can't just say stop, time out.
Yep.
And I found that through experience, and somebody said this is my first deposition. No, I think what I said was I preferred to let other lawyers who are better at it. I tend to ramble, but no, that wasn't my first deposition. I've given any number of them since then. In fact, I gave one 2 weeks ago. In case we're going to trial on pretty soon. But I find that criticizing a client during the deposition, like when you take a break, usually does more harm than good, because they're
Right.
already wound up, and so I generally try to say, it's okay, you're doing all right, just you might want to think about, but I low key it, because you don't want to, you don't want to just get them so tight if they go in and freak out. Ty paid Vic for being his client. No, although I probably would have represented him no matter what, because he is a great guy. I remember very distinctly the drive home after I went to meet him face to face, and my law partner called and said, what do you think? And I said this half jokingly. I said, well, I hope he's got some money, because I'm gonna help him even if he doesn't. And Don goes, have I told you I love you lately? I was like, yeah, okay, that's enough. But Ty has been doing depots since 1998 BC. Yeah, it sometimes seems like it. But yeah, to anybody who's wanting to go to law school or wanting to, be a lawyer or anything like that, this is a teachable moment for y'all. Everybody loves it when they win. Everybody doesn't take any skill at all to enjoy a win, but I've always felt like how you deal with adversity speaks much more about your strength and your character than how you deal with a win. By the way, it's kind of academic now, but I remember you and I talking about it. I had no intention of gloating it whatsoever if we had won. I just I didn't, we just weren't gonna do that. I figured you would.
No, I would.
Oh,
I was hoping it would happen. Tonight's
well,
very
look, it ain't quite over yet. Okay, I don't want get anybody's hopes up, but we haven't thrown every single punch we can throw, and so I've got some very smart guys on my team. We'll figure it out. If there are angles, we're certainly going to take a crack at it. Like I said, and there was a dissent in this case. I haven't gotten to the dissent yet. So bear in mind, it's two best.
I haven't seen the dissent either.
Well, it's dissent and concurrence. So I don't know what he dissented on, what he concurred on, but
yeah.
So a reconsider motion might not be quite as much of a forlorn hope, because all you got to do is flip one of the judges theoretically instead of two.
Here, this super chat's relevant. It says, "Hey Nick, do you think you would have done better than Ty if you were Vic's counsel? Be honest, flex if you need to. Lol." Yes, 100%.
Absolutely. I think you would have done better than me, Nick. So.
I would have done a much better job.
Of course you
would have. I would have made zero mistakes. I would have typed everything perfectly the first time.
No typos. No. The
judge would have actually offered to give me sexual favors.
Yeah, he would have just simply said to you, "What do you want me to do, counsel?"
And I would have said, "Oh,
we win.
The depths of my imagination are so deep."
So it is ordered, and that'd have been the end of it. Yeah, listen, I mean, I've said this to you, I think, on your show. I'll certainly say this to your audience. You're a hell of a lawyer. I tried. You remember I offered you a job.
Yeah,
but you're like, I don't want to move to Texas.
I don't want to live in Texas.
Yeah.
Actually, no, that's not true. I would love to live in Texas. I don't think I'll ever be able to end up living in Texas.
Yeah.
That.
Yeah. So, That's, so, yeah. Sorry, go over the super chats. And I forgot that was the purpose of the exercise.
Yeah. Jason McConnell says, lost his first case ever last month. Nurse sued. COVID obsessed judge says nurses equals heroes. My father sued the judge and won 30 years ago. Sometimes you get that judge. Got the award cut in half. Good. Judge calling me viscerally repugnant. Priceless.
Yes. You can be
Oh,
evaluated by the people that hate you.
yeah. Jack Riley says, for Ty, what is an item that you enjoy? What makes you happy to get? Low price to high as well. Please don't beat yourself up too much. Please be well.
Well, thank you for the kind thoughts. What is an item I enjoy, low to high?
Yeah, something you enjoy getting.
I don't know. um, uh, that's kind of hard to answer specifically. I don't know why, but it is. Well, I mean, I have a number of hobbies, so anything related to those hobbies, gaming, sci-fi, history.
Butt plugs,
No, um,
cock
uh,
rings.
no.
You don't want those? Like,
I don't even know what those are, and I don't really want
what
to
about
know.
lubricant? Like various, like flavored lubricant.
When I
What
did
about
buy a
that?
can of shooter lube to clean my rifle,
Mm-hmm.
yeah,
Clean my rifle. That's an interesting euphemism.
not a euphemism. No, no.
Mm-hmm.
I kind of walked into that one, didn't I?
Yep.
Yeah.
What about a
So
Baldo?
I'm going to go with no, even though I have
You
no idea
what? Do
what.
you not know what a Baldo is?
No,
How do
no,
you
but
even not know?
I don't know, but I'm pretty sure that if you're asking, I don't want it. So, oh, by the way, so I actually became a member of your little YouTube thingy a
You
while
did?
back.
Why?
I was bored.
Oh my
I
god.
was thinking, wow, well, I get some of those cool secret cooking videos or something.
Yeah, you technically do. I have to do another one really soon.
No,
Um,
I did you and I did Andrew, Legal Mindset. I'll probably do Joe next.
have you ever, like, if someone's feet were cold, have you ever sat on the feet or like inserted them under a butt cheek to warm up the feet of the other person?
Not that I can remember. No, I
What would
mean,
you say if someone said, look, their feet were cold, so I lifted a cheek and I let them in? Like, what would you say to that person? Would that be degenerate?
I'd say I got to go. Look at the time.
Okay. That was Drexel who said that, by
Oh
the
yeah,
way.
yeah, I know. Drexel and I are Facebook friends. We correspond
Well,
more
you
than you
talk
and I
about
do.
feet stuff with Drexel on
I'm
Facebook?
not
Is
even
that
going to
what
get
you just
into.
said?
I'm not even going to get into those conversations. That's got to be privileged somehow. But yeah, Ty regretting coming on now. Yeah, absolutely. I come on and say, yeah, disaster. Take full responsibility. Then I got to listen to this shit.
Well, this is penance.
Yeah,
Toesley,
fair enough.
speaking of feet, Toesley says, I have 20 Northern pesos for you, my man. I appreciate you. Oh, thank you. Thank you for the Canadian $20, which comes out to an American 1 gallon of gas. Phoenix Lord Asserman, I dig the art of war approach to leading your team, Ty. Sorry things went bad this time.
I appreciate it.
Mecca J. So there's really nothing else Vic can do. It's going to be annoying seeing the usual people cheering this decision act like a bunch of lunatics. I'm sure Vic will move on from this. Can't say the same for his hate group. Dude, here's the thing that you guys, not all of you, but some of you should understand about these people. The same 30 people have been kvetching about this for the past 3 years because, and this is the critical part of this. For 3 years, the only time they get interactivity and responses from anyone is when they talk about the case someone else is involved in. That's it. That's the only thing that gets them interaction on Twitter or whatever. That's why they go back to the well. When, like, for example, me, I haven't really talked about this case in the past 2 years because nothing's happened. And it's just like, well, we're just playing a waiting game. So you talk about it for just a second, say, hey, just, someone says, what's up with the Vic case? I don't know, waiting on the Court of Appeals. And then you wait and wait and wait. These people go back to the well every couple months because they get lonely, because they will never, ever be interesting. So this is their thing.
Oh,
So
yeah.
what? Like, they couldn't do anything. They didn't make Vic's life worse than it already was. The
No,
people who destroyed
they
Vic
did not
already did it.
destroy him. They did not destroy him, and that was their goal. So they failed on that. We didn't get the victory I would have liked, but they did. We did keep him from doing that. Now Vic deserves most of the credit for that, but I'm just saying.
But I'm talking about the people who So my use of destroyed, I think, triggered you. But
Yeah.
there are people who damaged Vic. We're talking about the defendants in the case and a couple other
Mhm.
people that are mentioned by the court. But
Oh,
then
you're
there's this
talking about the law Twitter
there's this
dipshits and
yes,
those.
there's this
Yeah.
group of orbiters around this thing. They can't and haven't harmed Vic. They're just these weirdos who talk about it because when they do,
Because they
someone
are
talks back.
so jealous. Because they know he's better than them in virtually every way that can be measured. And that's the thing, right? When y'all are talking about, oh, these assholes are going to gloat, let them, okay, fine, they're going to gloat. Would any of you guys trade places with those sad, pathetic fucks?
I got
It,
invited to go onto
I
Mike
mean,
Dunford's stream.
uh, I'll just send you
I
some pliers. You can pull your toenails out and get the same experience without having to waste the time.
I thought
I
about
mean,
doing it, but his show is going to go on at the same time as mine. I thought it'd
no,
be
God, no.
funny to go
I
on
wouldn't. I
there.
wouldn't take money out of my pocket. Certainly, yeah, that's true. If you could go on it, yeah, okay, I got you. But no, guys, I mean, really, seriously, they are all horrible, pathetic, miserable, worthless people. You know, so who gives a shit what they think? I, you know, I, I, let them have their moment. I mean, you know, I can't imagine an actual practicing attorney spending hours and hours every day on Twitter. That's just, you know, you ain't got no clients. And if you don't have any clients, you're not a lawyer. I mean, that's kind
Hey,
of the deal.
rude.
No, you got clients. You
No,
got clients.
I do not.
Well, you
I,
got some.
anybody who's my client right now is just waiting on a 9mm to the
Well,
forehead.
yeah,
Get
but of
away.
course,
Stay back. I'll pepper spray you if you call
what is
me
it?
again.
Well, yeah, but I mean, you're like the number two, super chat guy on YouTube now or something. You had some
I don't
accolade where you
I
did
don't
you?
want to be. I don't want to be a practicing lawyer. Like
No, no. Um,
that
but
sounds
yeah,
like so much fucking work. And then
it,
sometimes I don't know if you've heard this about lawyers that practice sometimes, but sometimes you lose cases and it's really shitty.
no, I've never seen that happen. What must that be like? Um, yeah, yeah. So I wouldn't say that the cause is completely lost. We have a few more punches to throw, but I'm going to be clinical and say that the odds don't look good for us, but we're certainly going to try. I mean that's what you have to do at this stage, and
Yeah.
it. But you know the thing is, the best thing anybody can do is go to the convention, see Vic, you know do the autographed photo. I'll tell a very minor Vic story, and I don't think he would be offended that I tell this, but this will tell you the kind of guy he is. I have a friend who's got an autistic son, and this son is pretty seriously impaired, but he just loves Vic, and just loves him. And so I called Vic on Christmas, the day before Christmas, or something, and I said, "Hey, would you mind recording a nice little Merry Christmas so and so thing for him and send it to me? It would make his day." Vic said, "Oh, of course." And so I get the video, and it's not just a Merry Christmas. Yeah, it was like a good 2 or 3 minute, just Merry Christmas. I hope you have a good thing, and yeah, it made that kid's day. And I didn't pay him for that. I didn't. I mean, but his response, of course he did. I mean, so these people that are gloating, they're gloating about damaging one of the better people I've known in my life. And so they're
Yeah.
scumbags. They're absolute garbage. So don't let your happiness be defined by what dumbasses do. I think I would give that advice if I to anybody.
It's
Uh, you know,
unironically very, very good advice.
yeah,
Um,
it's hard to do. I concede that. Your
yeah.
sense of justice is outraged. Believe me, and maybe to some degree, this is that in that category of do as I say and not as I do. So I don't mean to criticize anybody on that. But so anyway,
All right, I got one more for you, and then I'm going to kick you off, and I'll do the rest of the super
Okay.
chats.
Yeah,
Otherwise, I'll
this
never
won't
get
stop
done.
otherwise.
Yeah.
Fair enough.
Joshua Vidrine says, Ty, this is for you. Rough night. It's $20, but if you think I'm going to mail you a $20 check, you're fucking wrong. Rough night. Everyone's disappointed, but you fought a slippery battle that we can all learn from. Hoping to still see you here from time to time talking wargaming and telling tales. You're a great man.
Thank you. Appreciate the moral support.
And of course, Ty will be welcome back on the show.
By the way, the first person that called me when I sent a text out to several people telling them what happened. First person to call me was one of your uncles.
Oh yeah,
just to say, hey, you okay? So yeah, it's good to have friends in times of adversity, and I would advise everybody, try to remember that when you see your friends in times of adversity, because even if you don't know what to say, sometimes just hey, you okay, or slap on the back, whatever. People, that very often helps a lot more than we realize. So,
well, there you go. All right, man. Well, I'll bid you good night. Get off my show, and then I'll do the
super chats and go to bed.
I'll do the rest of the super chats. I do have to be up earlier than I want to tomorrow, which sucks. And then we'll be moving on. This is closure, though.
Yeah, if I could say this to everybody in the chat that has been supportive, appreciate that more than you can know. To your other gloating fuckers, piss off. You're pathetic. You just are, and you know it. You know it. We know it. So I don't know why you're even bothering, but whatever. All right, man. Well, hey, you have a good one, and see y'all later in the chat. We'll see how things develop over the next few days.
Talk to you soon, man.
Okay, brother. Bye-bye.
Peace. There we go. That was Ty Beard. And as kind of expected, Ty blames himself for the entire thing. Doesn't throw anybody else under the bus. Whatever anybody thinks of Ty, what I can say about him is he's a good man. He's an honest man, and he's a stand-up guy. He's not the kind of guy to try and weasel out of issues, responsibility, or problems. And that's something. With that, I am going to do the remainder of the super chats tonight, and we'll see where we are. I don't think so. Here's what I'm going to do. I'm going to tell you this right now, chat. I'm not going to do an unbreaded on this show. I'm feeling very breaded tonight. I will do 2 unbreadeds tomorrow, but I'm not going to do an unbreaded tonight. Doesn't feel right. It doesn't feel right. So, tonight could have been a gloat stream. Super happy, hilarious. It isn't a gloat stream. It is, it's morose and somber. And I don't feel like being the Pope of the unbreaded this evening, but tomorrow we will do 2. Tomorrow will be a stream full of more levity and comedy. Today was a serious one, and it had to be done this way. It just did. So it sucks because, believe me, my plan for if this had gone Vic's way was to literally laugh for 3 straight hours. Nothing else. Just fucking laughing. Didn't work out that way. It's too bad. Very unfortunate. But yes, we'll have a different, a normal type show tomorrow. Some good subjects. Probably that Florida judge ruling coming up, and some other stuff as well. I'm not sure if I'll be on Flashcast this weekend or not, because I'm supposed to not be on Flashcast this weekend. What I'm supposed to be on this weekend is one of my law school classmates and a good friend is cancer free finally. And we're going to have a celebration by trying to give this person cancer through liquor. That's what Saturday is supposed to be. But I don't know if I get to make it out because I burned a lot of my babysitting credit with the last trip. So I don't know if I've got anybody to watch the kids. If I have someone to watch the kids and we get to head out and get super liquored, Lady Rackets and I, that's what we'll do. If we don't have someone to watch the kids, then I'll be on Flashcast. So we'll see. We'll see. Other than that, let me get to the rest of the chats here. Thanks for hanging out with me, of course, and thanks for dealing with this real shitty outcome. Cody Byer says, big day for annoying people. Guess we'll have to settle for new anime studio giving us the dubs we wanted and Funimation being gone. Yes. Funimation is gone. It's just Crunchyroll now. And there is a new studio out there, which of course is something that you guys can support. It's the Anime Matsuri Studio. And people should check it out and check out their new stuff. If you're an anime fan, you definitely want to do it. I'm not an anime fan, so I really only want to check out their stuff that involves murder, death, robots, or whatever, or boobies. Fetty Chico, thank you for the super effective sticker. I appreciate that. Tilly T gifted 10 memberships and became a member herself. Thank you so much for that. I'm Stormin Mormon with a huge chat. Thanks for that. It says tonight is a gut punch. Had a tough month and was in need of a laugh. I just caught up watching the Vic streams ending on the Conversations by proxy today. Thank you for education and laughs. Good night, Nick. Sorry, brother. Tomorrow will be more full of jokes and levity and fun. Today has to be a somber day. And that, believe me, it's the last show I've ever wanted to do is the show we had to do tonight. Jason McConnell says, going to the Minnesota State Fair early September. Driving over to Wilmer on my way out to buy all the Go-Gurt to stuff in my ass. When your kids ask about the shortage, you can tell them daddy made a big gay mod and has only himself to blame. You motherfucker. You better not be lying. If you drive through this area and you don't stop and have a drink with me or something like that, like let me shove a Go-Gurt in your butt or whatever, then I got news for you. It means you're gay. You better let me know, you piece of shit, motherfucker, asshole, fuckstick, shitbag, cunt muffin. You better tell me if you're coming to town. All right. I think we got it. Over on Rumble, we've got Joe K84 says, Nick would be great to have Jersh on again. Would love to. Maybe to talk about Keffels and his jihad against Kiwi farms. No cut for YouTube. Who the fuck is Keffels? I saw this shit and I don't know who Keffels is. What is a Keffels? Does anybody know what Keffels is? So they're teaming up with Ethan Ralph, which makes me very happy for their future. Unfrosted Flake, Keffel's Deep Dive Stream, Canadian Troon. Oh, shit. Keffels is a Canadian transgender. God, that's 2 mental disorders in one. Fuck, am I allowed to say that? Shit. My channel is going to ban. Shit. Joe Schmo, 1 of 3. Hey, did Rial and What's Her Face ever record another podcast episode? Not necessary, huh? They did do a second one. I don't know if they did a third. Roy Rat, in every single case, in every courtroom, somebody has to lose. Nature of the system. It's a tough loss, but there's already a response plan in place. Rumble username sucks says, which version of Traveler does Ty play recommend? The old one. And is there any video of him DMing playing anywhere? I've been trying to get a game together with some friends, but I haven't been able to play myself. I don't think there's any video of that. Did you guys? Oh, Ryan, the editor. Yes. Guys, Ryan, the editor, is a fucking saint, and he's unfired forever, except for when I fire him next time. He sent me a bunch of shit from Anime Matsuri that people had given me, gifts and stuff like that, that I could not take with me to the Caribbean because, well, there's 2 huge fucking boxes. And that all arrived today. Thank you, Ryan, the editor, for that. Included in that is some great whiskey. Attorney Tom sent me a phenomenal whiskey that I can't wait to try and do a review of, but also a 2nd edition Forgotten Realms campaign setting. Oh. And on the same day that I received my 2nd edition original Forgotten Realms campaign setting box set, I see the new D&D, whatever the fuck they call it, One Dungeons and Dragons or some bullshit fucking name they've come up with to say, we're so happy with the system now that all your wheelchaired companions can play in forever. Ugh. Ugh. God. No, Ryan, everything was packed magnificently and arrived perfectly intact. I actually I know people hate this position, but I like the system of 5th edition only for this. Let's be very clear on this, because I know people are you're already pulling your pubes out and weaving a beard to come after me with them. I like 5th edition for streaming D&D games. I like 2nd edition because I fucking love it. I love 2nd edition. I thought it was so goddamn cool, and all the shit they had in there, and all the expansion books were crazy and fun. All right. I love 2nd edition. But for streaming games, 5th edition it's such an easy system that flows really well. It's like, oh, 2 of my kids like D&D. The smart one I'll give 2nd edition, and the slower one I'll give 5th edition. That's what it is. That's what it's always been. 5th edition is really great for streaming games, because you're not spending a ton of time in the system. You get to do a lot more narrative stuff, and the roles are really quick and simplified. 2nd edition, third and a half edition, these are great, and really complex and great systems for getting into fucking role playing and all of that stuff. And that's what I love to play 2nd. But I got to give 5th credit. They made 5th edition to be compatible with video games because it was simple, and they did it. They did it right. They made it in response to what's the game? Baldur's Gate 3 or whatever. They wanted a 5th edition video game version. So they worked with them to make something that would translate well to this online play sort of lifestyle. And they did it. And it's good for what it is. But for the rest of it, it's fucking garbage. And they're video, we love where the game is right now that just came out. God, I just wanted to sledgehammer everyone in the face and be like, where's the Minster, you motherfuckers? Gah! Where's the symbol? Bah! We're the 7 sisters. Gah! Where's Blackstaff? Kelvin fucking Blackstaff. Gah! Ilmater beats people to death with his goddamn hands, and he's a god. That's cool. Why? Why'd you take it away from me? Anyway, I just like 2nd edition, okay? They killed Kelvin Blackstaff? Oh, I hope they get a Blackstaff right up their ass. Anyway. Replace him with a black chick. What are they, fucking Disney now? You know, second edition was bad enough with Zachnafin getting pegged or whatever by Drizzt's mom. It's like, oh, the matriarchy of the drow. Like, that was the worst shit in second edition, was the fucking drow. Because the drow are the worst people ever. Because they don't socially integrate. And they maintain their own adherences to a violent culture of rape and death. The drow do this. And they all live in Detroit. Fuck! It's a goddamn Spider Queen welfare economy. No! Wait, I'm not supposed to have fun on this stream. This is a somber stream. This is sad. We'll talk about the drow tomorrow. Oh, fuck me. Here we go. Mario Carter 13. Monica Rial will have to forever live with the trauma of Vic flicking her bean in public, making it the second jelly bean people laugh at her for. Do I love drow people? I do. I love drow people. There's a lawsuit in Minnesota. Steve McRae versus Katie Joy Paulson. Nate the lawyer will make a stream tomorrow. Have you known about it? It's a total scam and GoFundMe by Steve McRae. Look, I knew that it was coming, but the way Minnesota does lawsuits is you can serve a lawsuit on someone and never file it and you have a year to file the thing. And if you do that, the lawsuit starts at service, but no one knows about it until it gets filed. So has that shit been filed? I'd love to talk to Nate about it. Steve McRae seems like a weirdo. Katie Joy Paulson is also a fucking weirdo. But I'll have to check into it. I'll talk to Nate. I haven't talked to Nate in a while, and I love that guy. Mr. Moshi says in preacher voice, "What's up, vinegars?" James Bursey, Ave Rackets. Do you know Razor Fist? I do know Razor Fist. I love that guy. I gave him a lot of money the other day. He also came on my show the day after the 2020 election, which was nice. He is currently making a Lincoln the Tyrant video. I think everyone really enjoyed if you two collaborated. We have collaborated in the past. He joined me on, like I said, after the 2020 election, the day after. He also joined me for a Michael Jackson stream a long time ago. I love talking to Razor. I think he's one of the best YouTubers that exists. And his rants are legendary. Music and Fiction says, looks like you need to bring Ty on, sir. I didn't think Ty would want to come on tonight, but he did. The year already passed. Steve took money in GoFundMe to file that lawsuit, but didn't file, and the year ended yesterday. Neat. Yes, a Razor Fist Battletech stream, very important. Battletech was one of the holdouts, and it has gone fully fucking breaded. They're Mazius. Vic's story has been told, and everyone knows the truth about Funimation, Rooster Teeth, Tweedledee, Tweedledum, and Tweedledummer. Gator time. A lot will be said by morons with no clue what the case is really about. This is about saving the life of a man that gave so much to others. They wanted him canceled, then dead, and he's still here. It is. I'm not, like, Gator's right. I'm not doing a cope stream on this. I'm trying to address this and confront the reality of the situation. I mean, there's a whole bunch of shit I could say about Vic's situation, all that fucking stuff, and it's all true. But I'm not trying to do that show. So that's why I didn't do that show. This show is literally about the appellate decision. So I tried to do that. Ryoji Mata says, F you, can the courts in Texas. Enigma the Basement Troll, you frequently hinted at having info via various, wouldn't it be a shame if Sabbath, Ron, Funny, etc. quotes? When can we expect that info to drop that you promised? I don't know that I haven't dropped most of it by now. A lot of it got dropped a long time ago. Some of my sources are skittish on this stuff. Here you go. Chris Sabat used the casting couch to make casting decisions. That should be obvious. And everything Vic has been accused of, he and Sean Schimmel and others have done far, far worse at conventions. They've actually been banned from various conventions for inappropriate activity. This shouldn't be a surprise to anybody. It's all just kind of leaked out over the past couple years. I mean, these people are fucking terrible. What they did to Vic wasn't about sexual harassment or anything else. It was about in-group, out-group thinking. Vic was a Christian Trump supporter. All of these are Biden supporters who like to take dicks in their asses. That's the truth. Especially Chris Rager. Chris Rager is a raging pile of garbage who loves dicks in his ass. Halo K1D4 says, prod this judge with a hot cattle prod. Just an Orca fan says Ron Toye is a pedo. Cowboy shit just coming in. Betting Ron Toye's smug self is chirping on Twitter right now. Dude is going to say the wrong thing to the wrong dude someday. The wrong thing to the wrong dude for Ron Toye is him saying, I don't want to suck your penis. All right, here we go. Next, Flying Bowser. Hi, Nick. I can't wait till Ron and Twitter start running their mouths saying they were right and everyone is wrong about the case. But that being said, thanks for the coverage for this case and to help Vic. We'll see what happens. Real Lesco Brandon says Hunter smoked all my cheese. Smoked cheese is good. Andrew Thetford, like Andrew Bronca says, folks, appeals are for losers. Very true. It's a true thing. Always has been. Okay, anyway, sorry, I had to in there. All right. Let's see. HS says, got my hands on a cheap Lafroig PX cask. Gonna try tonight. Go get it. Joshua Vidrine, this doesn't change the fact that eternal fiance Soye loves nothing more than cleaning up after Monica has been through a literal herd of bulls. Crocs 22. Hey, Nick, was nice to see you and Vic at Matsuri. Second time seeing Vic, such a nice guy. Happy to see you. Can stream again. Do you mind if I tag you on Twitter with that IRL super chat photo by the? No, of course not. Tag me on Twitter all the time with whatever you want. Matthew Spriggs, local beloved doctor dies. Senior paper reporter Google searched and rehashed man's recent marriage trouble post-coof. Pine Bluff AR is Jack Murphy. Shit. Not applicable says Monica and Ron are still defaming lowlifes. Young Pei Chang, Nick, what are you having tonight? A shitty night. Shitty night. I'm generally like, especially after my vacation, after I got some rest, that's the big problem for me. Like, not to get selfish for a minute, but this is all about me at the end of the day. I've been having such a good fucking time that I guess I had to be kneecapped a little bit by God and fate. But after my vacation, I'm so energized. I'm so happy and positive and relaxed and fucking calm. And then to have this happen really just took a damper. Took a damper on things. Kate J says, Nick, since it's now past midnight on the East Coast, I'm officially 31 as of today. Would appreciate to hear a gentlemanly toast. God bless. Kate J. Kate. happy birthday. 31 years, and I am so glad to see you're not doing that stupid meme of, I'm forever 29. Look, 20-year-old women are a thing. 30-year-old women, no, but sorry, women in their 20s are a thing. Women in their 30s are a great thing. Continue to be a great thing. Enjoy your 30s. May they be full of adventure, excitement, expansion, and a broadening of your horizons and experiences that is, of course, well within your moral tolerance. I hope that you find a companion, or that you have already found a companion who suits you, who fits you, who fulfills you, and who fills you. Enjoy your life, Kate. I hope everything goes great for you. Cheers. Jason McConnell says, headline, complaints to the manager reach historic lows in Afghanistan. Too soon. Fuck. Ethan Flash says, can you play Goku calling Gohan a fig audio? I don't have it right now handy. Maybe we'll do it tomorrow or something. Not Applicable says, she won't be a 10 in 20 years. You will. Shrug it off. Olaf, son of Rasmus, says, carbonated milk. Gross. Joe, conductor, we have a problem. Scotty Do 81, may I have a toast for my brother? He was stabbed in the chest by his girlfriend. He's recovering and doing better, but I thought I lost my brother for a while today. To brothers, the thing I say to my kids is this: when the world hates you, when your friends hate you, when people on social media hate you, when even the media hates you, the people who should always be in your corner are your siblings. They have your back when the world is attacking your front. To brothers, the only people with the license to make fun of us, to truly rip us apart, but to always do so with a smile on their faces and a smile on yours when you rip them apart right back. Cheers to brothers. I'm glad yours is living. Facts, not feelings. Please explain for confused news people who Susan is. Susan is Susan Wojcicki, the CEO of YouTube, and she's a cold bitch. Baby says, what's up, Nick? Hashtag I stand with Vic. Say golden, both Vic and Nick. Thank you, brother. Ray, where are we? Rolana 1. I don't think appealing to the SCOTUS would be a good idea. They look to have very full schedule coming up. I mean, they always have a full schedule. The appeal to SCOTUS, they're just probably not going to take. They're almost guaranteed to not hear this appeal. So that's why I say don't waste the time on it. It'll also increase fees that Vic would end up owing. Not the best choice for me unless they really think they have a case. I don't know. I haven't seen it yet. I'm willing to be convinced. Crocs 22, can I also ask you to toast to my cat Lucky? Put her down last week, pancreatic cancer. She was 14. Was in my arms when she went. She was the sweetest, friendliest, cuddliest cats you've ever met. Crocs 22 is a man who's held several cats as they pass along from this life into whatever there is after. Maybe it's just dirt. I don't know. It doesn't matter. As they pass from our lives, letting go of a pet, a friend, and a companion is never easy, even when that friend and companion hates your guts, as all cats do to their owners. It doesn't matter. What I can say about it is this: as much as cats despise who we are and wait for us to die so they can eat our eyeballs while we rot, that cat rested much easier knowing that you were there holding and comforting it until the very end. And I've said it before, but I'll say it again. That cat went to sleep knowing that it would see you when it wakes up. Cheers to your cat, brother. Fucking sucks burying a friend. Snubber 13. Dumb Dominique Sky is already cheating. Cheering this as a victory behind her locked account. Dominique Sky can never win again because she sells lewd pictures while being married. Amane Mizuhashi, Nick, even though the case was sunk and you knew there was a considerable chance of failure, do you think it was still worth fighting for? Yes. To Vic, his legal team, and his supporters. Yes. Yes, of course I think it was worth fighting for. I still think Vic is in a better place now than he would have been if he hadn't fought. Because I think if Vic hadn't fought, he would be dead. And I mean that without a sense of irony at all. So, yeah, I think I prefer the world we're in now, even though I would have preferred a different one, right? I would have preferred one where he won, but I'd take him losing to him being dead. Trident Titan, I've been here since this all started, and this is how I found your channel. All I can say is I hope Vic is doing all right and he continues to do so in the future. Me too, brother. Me too. Mr. Armageddon, I still like Ty. Some mistakes were made, though. Yeah, he talked about him. I've talked about him. Crusader says, Allah's peace be upon Ty and Vic. Asia Frazier, penalty for losing. Ty has to take a shot and mix it with soy sauce and lemon juice. Bonus points for attempting the Lemoyne voice after the shot. Gross. Ditzy, hope all is well for everyone. Battle Elf, Jesus lost his case too. Mike Sullivan, much respect to Ty for taking up for his team. Anime Collector, if I could just rally the troops for a moment, I think it's important that people understand where we go from here. They've lied and twisted everything with this case, from the apology to the Vic locks to claiming Vic admits he did what they claim. And he says, for fuck's sake, I can't send this message. Our job is to provide the corrective context to individuals who fall for these claims. I've set up resources at ocapodcast.com/Vic-archives where you can quickly access tweets, videos, etc. And please feel free to create an account on the website and comment additional things I should add. There you go. That's from the Anime Collector. Thank you. Yungpei Chang, I think the fact you guys fought and spoke up for 3 whole years and made sure folks knew Vic was seriously done dirty was a victory on some level. I agree, but it always feels she'd be like, well, but, you know, at least he fought, though. No, today was about acknowledging the loss because it's a real fucking loss. And it sucks. It sucks. It sucks. It sucks. But it is a loss. That's why I tried to do the show the way I did it. I'm not perfect. I mean, I am, but you guys aren't perfect, and you watched it the wrong way. But it is a loss, and there's no walking away from it or walking it back or being like, you know, it's not really, it was a loss. Of course it was. Of course it was. Tomorrow is the day where you go, you know, things are going to be okay. This. But I'm not trying to run away from that loss. Own it, accept it. It's what it is. And then we'll go forward from there. Training Marco says, so was Law Twitter right all this time? No. I mean, Law Twitter got the outcome of the case right. There's some reasons that they got the outcome of the case right, but the overall case was still meritorious. Vic still got fucked by gross people. And I do think he has a case that could be won. Had a case that could be won. But it was always a hard proposition. I think fighting was a critical element of it. I said that from the get-go. Fighting matters. I'd be interested, not that you'd want this on anybody, but I'd be interested to see his case in 2022. When Me Too is not at the pinnacle of power that it was at the beginning of 2019. So we'll see. I mean, but we'll see what happens. Again, Vic's now voice acting and ADR directing in a new anime studio by Anime Matsuri. This is something that maybe never would have happened without this case. And hopefully they bust in and shake the shit out of the anime industry. We'll see. Enter the QB, read that one. Froge, the fact the case was immediately thrown out in it of itself is a miracle. So getting this far was a fair W. Talking trash and truths. Lighter note, during Fair and Stream tonight, we discussed your plan for burning pedos on rotating crosses. I named them rotisserie rapists. Crusader Saracen Ty, how have you applied Art of War to law practice? And Mecha J, Vic's name is already trending on Twitter. I'm not sure if it's trending in a good way or not. We'll see. Here we go. Jesus Davila says, game over. You know, I do want to say, though, in a way, it's nice that this is done. The Vic case is done. That chapter is closed. To me, I know Ty said we can do this, we can do that. Whatever. To me, the Vic case is largely done. We were waiting on this appeal to come through. It's come through. It's not favorable, but at least it's fucking over. I don't want to live in the past of the Vic case anymore. Like, I don't want to live in that shadow of that case. It's too long. So we'll see where we go from there. Magician Sapphire, man, this is a kick in the no. Hope Vic is staying strong. Is the GoFundMe still up? I want to show him some support. Thank you, Nick. The GoFundMe is still up. Look, here's the deal, though. On the GoFundMe, Vic Kicks Back is still there. I have not promoted the GoFundMe since the appeal started because once the case was lost, I was not going to bring up the GoFundMe and be like, oh, donate money. The case is lost, because the appeals are fucking hard. They might not. The likelihood was that they were not going to win. I'm not here to promote the GoFundMe and to say everybody should do it, blah, blah, blah. No. Like, if you want to donate to Vic's GoFundMe, you certainly can. But the case was lost and is now kind of over. Like, for me to promote the GoFundMe is dishonest, I think. And I'll probably talk to them about closing it out. So it's never been about that. It was about fighting the legal fight. The legal fight really slowed down and basically stopped while the appeal was filed. I wasn't really comfortable promoting the GoFundMe a ton of times after that. Atticus says, hey, Nick, glad to see you're back. I'm sorry I missed you in Houston. I'm currently trying to get into whiskey and sipping on some Southern Comfort. Is there a better one for a similar price? I don't know how much Southern Comfort costs. The answer is yes. Buy fucking anything else. Try Rebecca Creek. Not an expensive whiskey, but like, how much does Southern Comfort even cost? Don't buy that shit. What about the knives? I've got to figure out what to do with those. We'll do them as a benefit, I think, for Vic. And the knife proceeds will go directly to Vic. We'll make some fun thing out of it. I'm not sure exactly how. Maybe I can get him on to promote him. I don't know. We'll figure it out. But let me say this. What was I going to say? Oh, the best ways to support Vic. Go see him at a convention or a thing. That's the best way to support him. Sure, you can donate to his GoFundMe or whatever. Go see him in person at a thing. Get an autograph, take a picture, whatever you want to do. Have fun. That's the best way. He loves talking to people. He loves seeing people. All right. Okay, Kidda says Keffels brings up an interesting legal question. Is it legal for a transgender dominatrix fart porn star to run a narcotics and grooming ring to get children illegal hormones and puberty blockers without parental consent? God, I fucking hope not. Atlas Knife and Tool, heading to Mankato to teach a knife making event today and tomorrow. Are you too far from there to have a drink? I'm an hour and a half from Mankato. Atlas Knife and Tool, email me. Maybe we can work something out. Kidda says D&D 6th edition was announced like an hour ago. Here's a trailer, D&D 1, now with VR and NFTs. No, it's the same core rule set of D&D 5th edition, just new. And I know. They're like, no, this is the D&D forever. Until they realize how much money they'll make with 6th edition, then that'll change, probably in like a year. Miss Mayhem XOX DM'd on Twitter. A guy tried to run over an off-duty cop caught on his door cam. No one was seriously injured, but it's a crazy video to watch. Kidda, message retracted. Ultraman ZX, can I get a toast for my cat Sundry? We had to put my 15-year-old kitty down a week ago. Her quality of life was failing badly, but I miss her dearly. I had her for the most of my life, and now she's gone. To Sundry. A cat, a companion, who stuck around for so long, 15 years. It's an immense amount of time where you change a ton and your cat barely does because they hated you from the moment you got them to the moment you lose them. To Sundry, to always pushing shit off of shelves and tabletops in the afterlife, may you never run out of casual breakable glass items. Cheers. Known important, I've been here since the Shane stream. Hope that little inner circle at Funny gets demolished somehow. Also hoping for one more conversation from this. We'll see. Kim Bentz, still got the whiskey drinking lawyer song in my head from last night. Nick, why do you call yourself a boomer when you're obviously Gen X? The boomer is more a reflection of my inability to operate technology properly. That's what that is. And then Jason McConnell, headline, complaints to the manager reach historic lows in Afghanistan too soon. Shit, I read that. Ethan Flash, can you play Goku calling Gohan a fig audio? Not tonight. All right, guys. That's it. We're going to bed. I'll see y'all tomorrow. No Twitch tonight. I'm gonna start Twitch up really soon. I have some plans for Twitch. Streams just keep going 4 hours and I keep having early mornings and I can't do it. If we have to switch Twitch to before the show, I'm going to strongly consider figuring out how to do it. Because I need, like, again, I know you guys are like, oh, he's not doing Twitch. Twitch is my time to wind down and have fun. If I'm not on Twitch, I'm not watching TV and I'm not playing video games, which means I'm just fucking working or working with doing stuff with the kids and stuff like that. And I need some leisure. So it's going to happen really soon. Sorry, it's not tonight. Elian, win or lose, Vic is definitely doing better. He will succeed and move on to bigger and better things. As for Kick Vic, they're just sad and pitiful. Yeah, that's the thing. Vic doesn't live in 3 years ago. All of these other people do. So with that, until next time, peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitter and Erlang. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of that brug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter, as we hear Lost Blaming tonight. From the wide shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out a glass for the tea, post on Twitter, as we hear Lost Blaming tonight. From the wide shores of Nam to the hills of Glenlivet,